Welcome to my world. Come on in and make yourselves at home. Welcome to my life. I know everything's gonna be all right. Welcome to my world. Oh, won't you come on in? Welcome to my life. It's known as the Tiger's Den. Greetings to all of my subscribers. I want to thank you for being with me for as long as you have, and the new subscribers that's coming on in. We want to say greetings and thank you for your time. This is from Toothless and the moderators. Welcome to the Tiger's Den. This is the voice of Cheryl, and I am Toothless Tiger. I bring to you tonight a true story. I'm getting right to it tonight. I'm not going to wait a little longer to see who's coming in. I'm just going to get started. And perhaps we'll have people watch the replay. Because I got a lot to share tonight. It's a lot been going on, but I started the other day, and I can't remember what day is which. So is today Wednesday? I believe it is. I started on Sunday telling you guys all about the Georgia immunity laws. And I stopped on page 11. So I'm going to start back with the immunity laws, but we have some videos to watch because of the way I see things. And I've been putting out little Instagram posts of certain clips. And one of the ones I put out was one where D.A. Love asked the judge at the end of the day on the 7th for an ex parte meeting. Now, that's the one she asked for in the courtroom, so I don't think that was an issue. I think there were two ex parte meetings. I think they had one that Friday, and I think that's when she and Hilton and the judge colluded on how it was going to go on Monday. And this is just one woman's opinion. Take it for what it's worth. But as the transcript has come out and certain things that are being said in the transcript, you know that there are other conversations that had to have taken place because you don't see them in the transcript. Now, he said he was going to put out the full transcript, but the way some of it reads, that's not true. And that's only if you're using your analytical mind. But I believe that they came up with the idea, since they had given him immunity, they did that Thursday. When they got the email from Melnick on Thursday, they ran in on Friday morning because he was going to be in court at 9. So they came in, they contacted the judge and came in, and he signed the order. But if you listen to how he describes it when he's talking to Mr. Copeland when they're in the secret meeting, he's telling how it could have happened, not how it actually happened. So it's really some interesting stuff. And then what really bothers me about all of this is a lot of people, and it's a lot of content creators, you learn the game as you go. And I've been here 3 years now, and I'm still learning. And they click up. And so I noticed that a lot of people are not reporting on this story for the injustice that's happening to our sons. They're reporting on the story for the sensationalism and the content and how they can spin it. Their titles, when they have the conversations, and they get an awful lot of money. Now, I don't envy them. I certainly wish I had as many donations, but it's not for the lack of envy, because I'm not going to do the stuff that they do. I'm not going to come on as often as they come on, and I'm certainly not going to tell a story. I came on here to uplift fallen humanity and to try to teach us how to advocate for ourselves. Hey, Phyllis, and anybody that's in the bushes, because I see it's 4 people in here. If you would, please hit the like button for me. I would greatly appreciate it. But I can't do the stuff that they do, so I'll probably never get the money that they get, because I'm probably never going to be as entertaining, because I see a lot of people see this as entertainment, but these young men are facing life in prison, and Mr. Williams is facing a life sentence, and he's not even a convicted felon. That's what they're trying to do to him now on a RICO charge. That's asinine. But I'm going to finish reading this about immunity, because I see that today that's a lot of talk has been about immunity, and that's a good thing, because the problem came when Mr. Copeland's lawyer contacted them. As long as they thought they could get away with what they were getting away with, then they thought that they had it made, and that's unfortunate. I really wish more people were interested in these men's lives. I wish they were interested in injustice, because you never know when you might be the one that's being falsely accused, or being what we used to call railroaded when I was growing up. You never know when it could be you or your child. So I'm going to start back on page 11, and we're talking about the different immunities. Remember, there is 3. And me and these glasses, my eyes, and this computer, I hope we do well. That's why I don't be on camera much, because I'm straining so. And so I'd rather do it off camera. Here we go. While conceding that the 5th Amendment itself, actually the 14th Amendment due process clause, which makes the 5th Amendment right applicable to the states, would have prohibited the use or derivative use of the appellate testimony had she testified, regardless of the validity of the immunity granted. Now, I remember reading that, actually. So we're going to go to page 12, which I thought it was 12, but when I started looking at it, I couldn't tell. But I read that. Now, remember the 3 immunities. We have use immunity, derivative immunity, and we have transactional immunity. Very important that we know the difference. So I'm going to start with the first sentence. Georgia's Witness Immunity Statute. The Federal Witness Immunity Statute, which was extant at the time the Georgia statute was drafted, and which in effect had been commended to the states as a model law by the United States Supreme Court and Castiger, contained a proviso specifically obligating federal judges to issue compulsion orders when asked to do so by the prosecution. Therefore, it could be argued that the omission of a similar provision from the Georgia statute, and reflective of a legislative intent to accord Georgia Superior Court judges the authority to evaluate the desirability of compelling testimony given the totality of circumstances of each criminal case. Relatively recent federal case indicate that Georgia courts would be on firm ground constitutionally to claim substantial control over the issuance of compulsion orders. And so compulsion orders is kind of like has to do with like the mental. It attaches to that. The application of the federal immunity statute as a prosecutorial weapon exclusively has been challenged pervasively on due process grounds. There are now indications that federal courts are no longer going to acquiesce automatically to every government request for compulsion orders, despite the wording of the federal immunity statute. Federal appellate courts, as early as 1966, had adopted the position that it would be a denial of the fundamental fairness required by due process of law if government were to use the immunity procedure to compel testimony from prosecution witnesses while refusing to apply for grants of immunity for important defense witnesses who might have refused to testify on self-incrimination grounds. In the leading case of the United States v. Alessio, the United States Court of Appeals for the Ninth Circuit finally ruled that such a denial of reciprocity by the government would violate the Fifth Amendment's due process clause. The Alessio opinion furthermore advanced the following principles relative to the application of the federal immunity statute. Number one, the executive branch of government has exclusive authority and absolute discretion to decide whether to prosecute a case, and consequently cannot be compelled by the courts to extend immunity to a prospective defense witness whom it may wish to prosecute. Number two, the executive may not use the exclusive authority. However, let me go over here because I cannot see down where that is. Let me hide that. I might can see a little bit better. Okay, authority, however, in a manner which denies the defendant the due process guaranteed by the Fifth Amendment. And number three, in each case, therefore, courts must determine whether the defendant would be denied a fair trial because of the government's refusal to seek immunity for defense witnesses. Okay. Let's go to the next page. By adopting this set of principles, the Ninth Circuit Court of Appeals implicitly claimed for the judiciary the constitutional authority to exercise complete control over the issuance of compulsion orders. Although the federal immunity statute obligates federal judges to grant use and derivative use immunity to prosecution witnesses when requested to do so by the executive, the higher law of the Constitution proscribes such action if it would mean a denial of the defendant's right to due process of law. And while only the executive branch can request grants of immunity for key defense witnesses, the higher law of the Constitution would be used to support a judicial ruling that unless such a request were further forthcoming, the case against a defendant would be dismissed on due process grounds. The Alessio opinion presents a cogent rationale in support of judicial control over the issuance of compulsion orders, a rationale which it is hoped will not be overlooked by Georgia courts as they proceed to develop the state's immunity statute. To vest control over the granting of witness immunity exclusively in the prosecution would most certainly be contrary to the adversary ideal of two evenly matched contestants engaged in refereed combat to determine truth and achieve justice. The power to compel witnesses to testify in exchange for use and derivative use immunity is one which should be exercised with the utmost caution. Indeed, only as a last resort, in order to protect the right of prospective witnesses against compulsory self-incrimination and the right of defendants to due process of law. That didn't happen in this case. What happened in this case is this young man had been talking to them for a week, telling them that he wanted to take the fifth. They're telling him, we need you to testify. We need you to say whatever it is we want you to say. And maybe they told him what to say, maybe they didn't, because they didn't record the conversations, which is not good lawyering. But when you're the prosecutor, I guess you can get away with not being good lawyers. So what ended up happening is, because his attorney was notified, and his attorney sent them an email to let them know that, Miss Love, you know you're not his attorney, and you know I am. Then they decided that they were going to contact the judge and let him know, we're coming first thing in the morning, and we need you to sign this immunity because we need him to testify. But we're going to give him use immunity. And what that means, as I explained in the beginning of this article, use immunity means only what he say while he's in that courtroom on that stand. And if he's not implicated by anybody else. Because see, they're not going to prosecute him for what he says. But if independently they find out more stuff about him, they can prosecute him for that. That's use immunity. Derivative immunity goes a little broader, and it can cover anything in that courtroom. Transactional immunity is even more broader, and it can really exempt him from all future prosecutions. But they were not offering him those two. They just offered him the use immunity. So we got to keep that in mind. It should be recalled that the United States Supreme Court has repeatedly held that in order to displace the Fifth Amendment's guarantee against compulsory self-incrimination, a grant of immunity must leave the witness in substantially the same position as if he had claimed his Fifth Amendment privilege in the absence of a state grant of immunity. Meaning they got to be able to tell him that they're not going to do anything to him. I see we have 101 that joined us. Greetings. Okay, Phyllis, let me see. It's all about the dollar. Yep, that's so true. Injustice to one is injustice to all. True again. You people know you have the right to take the fifth. Say nothing. If you want to remain silent, then remain silent. It's your right. Exercise your right. You have to know you remain silent. But this is why we're doing this immunity thing, because what they're doing is they're using the immunity to keep you from remaining silent. And they're not giving you the one that's going to keep you free. It's not going to be used against you what you say. It's going to be used against you what all come out in that trial. Unless you have transactional immunity. And see, this immunity he didn't ask for. He didn't want it. They are using it as a tool to make you talk. And that's where the problem lies. When you know what's going on, then you know what motions to file, and you can object to this type of thing. And they said, no, nobody can do anything about it. Well, here is their statute. This is their act. And he wasn't given the immunity for the reason that they claim that they had the ex parte meeting and gave him the immunity. They're saying because of what his lawyer said in an email is why they decided to do this. No, this was all game. And it's not going to turn out good. I don't know what's going to happen, but it's not turning out good for America. And what's even sadder is that our people are not even interested in what's really happening and the injustice. They're only interested in the sensationalism of the story. And that's what breaks my heart. But who cares about my heart? Even a grant of transactional, that's the best one. And listen to what it says. Even a grant of transactional immunity, however, does not fully meet this standard. At best, a grant of immunity will prevent the government from prosecuting a witness compelled to testify to involvement in a criminal activity. It will not protect him from a variety of informal social reprisals and penalties, such as public obloquy, loss of job, and even dissolution of family ties. Meaning that one would keep you from being prosecuted, but your whole life may be destroyed just because now people know what all you have to confess to. That's what that's meaning. Furthermore, it does not extend to civil proceedings which might be initiated on the basis of information contained in compelled testimony. And one line that was very interesting to me was the line that I read that said, at best, a grant of immunity will prevent the government from prosecuting a witness compelled to testify to involvement in a criminal activity. Now remember, this young man is not even listed in the RICO charge. So why would they grant him immunity if they're not accusing him of being involved in the charges in which they have charged all of these young men with? That's a really profound statement, and let you know that the state means no good where these men are concerned, and certainly not the witness. They gave someone immunity who wasn't even involved in the immediate crime. Makes no sense. But that's what they did. As a result of being forced to reveal damaging information about his activities, a witness may find that the judgments rendered in such civil proceedings can be as damaging to his interests as a conviction for a criminal transaction. There is substantial evidence to support the thesis that because of concerns to protect persons from such non-criminal penalties, the framers of the Fifth Amendment intended to establish an absolute right to silence by including the proviso that no person shall be compelled in any criminal case to be a witness against himself. The Supreme Court ultimately rejected this interpretation of the scope of the guarantee by the narrowest margin in Brown v. Walker, and reluctantly concluded that some means of compelling persons to testify in criminal cases is essential to the effective enforcement of criminal law. Even while upholding the constitutionality of a governmental grant of immunity as a trade-off for a witness' Fifth Amendment privilege, the United States Supreme Court has on occasion indicated that it is not entirely comfortable with the practice. Justice Frankfurter, for example, speaking for the court in the case of Ullman v. United States, expressed this underlying discomfiture in the following dictum. They, the framers of the Bill of Rights, made a judgment and expressed it in our fundamental law that it were better for an occasional crime to go unpunished than that the prosecution should be free to build up a criminal case in whole or in part, with the assistance of enforced disclosures. And that's what these people are doing. They're building a case as they go because they don't have one. They're going back to 13 and 14, and I'm talking 2013 and 14 and 15. And they did not prepare the witness because they did not let him see the very tapes that they're impeaching him with. They didn't let him refresh his memory like they did with the police officers. They let them refresh their memories by looking at the tapes so they could know what they were going to be talking about. They didn't give this young man that opportunity. Apart from concern that the indiscriminate wholesale use of immunity grants by the prosecution could result in substantial harm to immunized witnesses, contrary to the spirit of the Fifth Amendment privilege. And I'm not reading the footnotes because, like I said, we have a lot to go over, but I think it's pretty interesting and kind of can help you understand and tie some of this together. Practice could also deprive defendants against whom compelled testimony is directed of their right to a fair trial. Critics of the practice contend quite plausibly that immunized testimony is inherently unreliable and therefore likely to result in grotesque caricatures of the due process model. One of the more outspoken opponents of continued prosecutorial control over the issuance of immunity grants in Judge Warren D. Wolfson of the Circuit Court of Cook County, Illinois, an official who has had the opportunity directly to observe and evaluate the practice over an extended period of time. He succinctly summarized his conclusions in the following passage from one of his recent articles. The testimony, in effect, is purchased. So he said they buying this testimony. The government gives a reward, a very great reward. The seller witness knows that. He usually is smart enough to know what is expected of him, especially after conversations with an agent or a prosecutor. So he tailors his story to fit the expectations. He is believed and accepted. Boy, that's deep. That's deep. So we let the guilty free and we let the innocent go locked up. Basically is what this is saying. The prospect of being prosecuted for perjury, Judge Wolfson implies, does not sufficiently deter witnesses anxious to earn their reward of immunity from shading the truth to please the government attorneys. One rarely hears of a perjury case brought against a cooperative witness, regardless of the most persuasive evidence that such a crime occurred. Thus, prosecutorial control over the issuance of immunity grants, it can be argued, may present an irresistible temptation to the seller-witness and the prosecution alike to vitiate the defendant's right to a fair trial. And that's just kind of like just diminish it, to make it weaker. Not only may the constitutional rights of witnesses and defendants alike be jeopardized by prosecutorial control over the granting of immunity in criminal cases, but the public's interest in being protected from criminals and be significantly and adversely affected. Persons who are accorded immunity are ordinarily participants in the criminal transaction about which they are ordered to testify. So did you hear that line? Persons who are accorded immunity are ordinarily participants in the criminal transaction about which they are ordered to testify. So we know ordinarily doesn't mean always, but then we know nothing is always. So that normally means if we're going to give you immunity, you were part of whatever was going on. But this young man is not a part of anything. He's just a witness. Amazing. But what they're saying is that he was a part of back in the day. And that's what's scary. Ostensibly, they are granted immunity on the basis of a prosecutorial judgment that their testimony is essential to convict the more important participants in such transactions. Although such judgments might be valid in some instances, it is conceivable, at least, that immunity might be granted unnecessarily by prosecutors anxious to establish an impressive record of obtaining convictions. And that's what this all appears to be. All of this trickles down from Fani Willis, who is the DA and loved talking about her constitutional right of being an elected DA. Overly ambitious or, conversely, indolent prosecutors could well be tempted not to wait for the completion of the investigation phase of a criminal proceeding, or to exert the effort necessary to conduct a thorough investigation if they conclude that quick and easy convictions could be obtained by compelling some potential defendants to testify against others through the application of the immunity mechanism. To the extent that prosecutors succumb to such temptations, the public interest in securing the conviction of all persons involved in criminal activities is attenuated. Now, they claim they care about the public interest, but do they really when they let the guilty go and lock up the innocent? And we're talking about for specific crimes. That's what we're talking about. On the basis of such considerations, it appears absolutely essential that Georgia courts construe the state's immunity statute as vesting control over the issuance of immunity grants in the judiciary. Furthermore, in exercising such control, the court should be fully as receptive to requests from defense counsel to obtain vital testimony through compulsion orders as to similar requests from prosecutors. Fundamental fairness, as required by due process of law, clearly dictates this sort of balanced approach to the application of the immunity statute. The immunity statute, of course, stipulates that only the state prosecutors may request compulsion orders based on immunity grants. Georgia courts, however, could virtually require prosecutors to initiate such requests for defense witnesses whose testimony might appear to be essential by invoking a variety of sanctions, from threatening to dismiss a criminal case altogether to instructing the jury to consider the prosecutor's refusal to apply for an immunity grant for an important defense witness as indicative of prosecutorial concern that the prospective witness testimony would prove to be exculpatory and most persuasive. While adopting this sort of an even-handed approach to the granting of immunity, superior court judges would be well advised to issue compulsion orders only on a showing that such action is absolutely essential to the ends of justice. A conservative and skeptical approach to the application of the immunity procedure is necessary to afford protection from the real and potential abuses of that procedure, which have troubled thoughtful critics over the years. Testimony purchased with an immunity grant ought to be regarded as suspect. Hence, courts should require that the counsel requesting such a grant demonstrate the essentiality of a compulsion order and allay doubts as to the credibility of the prospective witness for whom immunity is being sought. Courts should be especially wary in evaluating prosecutorial requests for immunity for potential co-defendants. The government ought to be required to demonstrate beyond any reasonable doubt that it is not merely seeking a shortcut to conviction. Lord knows we know that didn't happen in this case, because they did this after receiving an email on Thursday evening after 6. By 8 o'clock they were having that. It has, on the contrary, conducted an exhaustive investigation of the criminal transaction at issue, only to conclude that without the compelled testimony of persons involved in that transaction, no conviction would be forthcoming. None of that holds true in this situation. Finally, Georgia courts should attempt to establish that a witness' compelled testimony cannot be used against him in a civil action. As matters stand now, testimony compelled under a grant of immunity may be used in subsequent civil proceedings. It is quite simply impossible to rationalize this position with a general rule that persons forced to testify under a compulsion order should be left in substantially the same position as if they had claimed their Fifth Amendment privilege in the absence of a grant of immunity. There is nothing to prevent Georgia courts or the General Assembly from acting to discord this ignoble and defensible ruling by adopting a more enlightened and liberal construction of the Fifth Amendment privilege than that currently held by the United States Supreme Court. Until the extant rule has been changed to afford the full measure of protection that the Fifth Amendment guarantee requires, however, Georgia courts should be especially reluctant to issue compulsion orders if there is any indication that a civil action against the witness, based in whole or in part on his compelled testimony in a criminal proceeding, is probable. That's the same like they shouldn't have allowed anyone to come to the stand and plead the fifth before the jury. But again, I believe there were 2 ex parte meetings, one on Friday evening when she asked for it in open court, and then the secret one they had Monday morning, and when they had decided how they were going to do it. And that's just, again, one woman's opinion, based on what I heard on the tapes. Hi, bae. How you doing? Conclusion. The Fifth Amendment provision that no person be compelled to be a witness against himself in any criminal proceeding is the linchpin of our accusatorial system. While it is axiomatic that no constitutional right is absolute, the great right of the Fifth Amendment merits a degree of protection comparable to the fundamental guarantees of the First Amendment. Therefore, Georgia courts ought to be extraordinarily cautious in determining whether or not to displace that right by compelling witnesses to testify in criminal proceedings. To confess to participation in criminal transactions in exchange for use and derivative use immunity from prosecution. Even a grant of transactional immunity would not leave a witness compelled to testify to criminal involvement in the same position as if he had successfully invoked his Fifth Amendment guarantee, since although he could not be prosecuted for transactions about which he testified, he would very likely be subject to informal social reprisals and possibly become vulnerable to civil lawsuits as well. Oh, so Alicia celebrate the 19th month. Yay! So Alicia. Hey, so Alicia. Consequently, it would be most appropriate for Georgia courts to apply a preferred status doctrine similar to that utilized by federal and state courts to protect First Amendment freedoms in evaluating requests for compulsion orders. In essence, this would mean that all requests for grants of immunity to secure compelled testimony, whether emanating from the prosecution or the defense, would be presumed violative of the Fifth Amendment's right to silence. Under this doctrine, only the most cogent and persuasive arguments that a compulsion order is essential to the public interest or to prevent a gross injustice from being inflicted on a defendant would suffice to sustain a petition for witness immunity. Judicial control over the issuance of compulsion orders and the principle that such orders based on grants of immunity must be made available equally to the defense and prosecution appear tentatively to have been read into due process clauses of the Fifth and the 14th Amendments by federal courts. Although the United States Supreme Court has not formally affirmed the Ninth Circuit Court's ruling in Alicio, the fact that the nation's highest court has allowed that ruling to stand implies endorsement. Georgia courts, therefore, would have ample grounds for asserting judicial control over the issuance of compulsion orders. Furthermore, by exercising that authority in a manner consistent with the preferred status doctrine suggested above, Georgia courts could challenge the nation to move toward a more demanding standard of due process. Historically, the United States Supreme Court has assumed the role of guardian of our basic constitutional guarantees, protecting them against the seemingly omnipresent threat of attenuation by state governments. That at least has been the impression created by the case law developing the 14th Amendment's due process clause as it applies to state criminal cases. While state courts are obligated to apply due process norms established by the United States Supreme Court as the minimum definition of fundamental fairness in criminal cases, there is nothing in the federal Constitution which precludes state courts from establishing due process norms, even more protective of the defendant's right than those required by the Supreme Court. By applying a preferred status doctrine in cases involving the guarantees against compulsory self-incrimination, Georgia courts could demonstrate that the United States Supreme Court is not alone in its efforts to elevate the standards of due process. Concomitantly, Georgia courts could thereby promote the public interest by encouraging the prosecution and punishment of all persons involved in criminal transactions. And that, my dear, is the end. So now we understand immunity, and we understand the trickery of the prosecutor's office. The worst part about the trickery is Fani Willis is aware of this because she is the DA, and remember, everything goes by her. So she knows exactly what's happening in this case. And that's what's sad. Now, we're going to go on to the case because, like I said, a lot is happening. You know, the judge I just want to remind y'all of his arrogance and how he treated and talked to Mr. Steele. And then I have this attorney, and it was really interesting. I seen several people use them today, but I seen them today, and I certainly knew I was going to use them because I love it when this young man and his father get together. His father used to be a federal prosecutor, and he's an attorney, and the young man is an attorney, and it's the lawyer you know. But he and his father worked very well together. So I want to go here. This is I want to go day 87. And that's not day 87. That's him and his father. We're going to go to that, but I want day 87. And I thought I had it already. That's day 88. Here's day 87. Day 87. And let me just look at the dates. Make sure that's the right date I want. Yeah. Okay. There's some things going on in these videos that, first off, where was that? Like 107, 104. We want to see, I need y'all to really pay attention to this because this is really going to tell the story. That woman there, she really needs to just shut up. I mean, it would be just good if she would shut up, but she won't.
Whether or not he took into account what I heard on the video, which was
This is the 7th of June. Let me look at this date again. I want the 7th of June. That's not it. It's not the 7th of June. I don't know how we got there. That's 3 months ago. That's not what we want. We want day 87. This is what we want right here. I'm sorry, y'all. I had all this already queued up, I thought, but you know how I can mess up stuff. Let me take this down right quick. Okay. Oh yeah, you saw that? Yeah. Yeah, that's good. I tell you, they did a very good job, but I've never seen nobody really break this case down like E-Man Films, and he's called Posted. He does it with such compassion, in my opinion, and for the injustice of what's happening. He has street knowledge, he has music knowledge, and he's very, very intellectual. He, to me, is an adult prodigy. I don't know if he is or not, but that's the way he come across to me. I'm trying to stop sharing this, but it's not going away. There you go. Yeah, but I need y'all to see what I see. And y'all can tell me if y'all see this too. But you can see the whole game. Especially the way she came up here talking to Your Honor like this is their first time having this conversation, knowing that they got him to sign the papers that morning. But I want y'all to just hear how she believed, and she believed. But by the end of the day, she's going to have so much anger when Mr. Melnick comes, and she's going to know. But it's just amazing. And I've shown y'all this before, but I think that we more care about the people that's involved and not just the sensationalism of what's going on. And that's what it's all about. You know, maybe with all of us sending positive vibrations and those that pray prayers and whatever you do toward these families and for our children, period. You know, it's just really sad that we're going through this in 2024 and our people are no further along. We think this is a joke and entertainment. And this for me is a second stream of income, but I try to bring information that you can actually walk away from here having some knowledge of what's going on and not just laughing at how funny somebody look or sound on the witness stand. These people's lives are really being affected. And some people don't care about criminals, you know, but before they were criminals, they were babies. And they were somebody's baby, and we don't know what kind of life they had. And even if they had the best mom and the best dad, the world wasn't good to them. All you got to do is go to school. And don't you go to school and don't have lunch money and everybody's eating but you. Or don't go to school one time and your hair wasn't combed. Or your mama combed your hair and your headscarf came off in your sleep and she made you go anyway. You know, it's a number of reasons why people have life traumas. And it ain't always those things that we can see. Sometimes it's just the way somebody look at you. Or the way children shun you. It's kind of just like this YouTube community. No matter where you go, these people click up and they support one another and they give each other. I seen them giving each other 10 gifts and 50 gifts, but they're all the same people. And they have a lot of people. So they rotate. And, you know, that's the same way it was over when I was in that other sector. And, you know, I thought everybody was supposed to be coming together to support one another. And I realized that not many people support you. There are a few, but not many. So you just have to do what you do because that's what you like doing. And that's what I do. And so let me go on to show you this little thing that I came up in my mind. This is what this has taught me. And I understand the trickery in the courtroom and with the attorneys, but I do know that there are some integral attorneys and there are some integral judges. We have integral people in all walks of life. Not many. The system won't allow for it. But there are some, and they do their best to do what they can. But it's a whole system we fighting. And then a people that's not interested and don't believe it can happen to them. And of course, we're going to do this for fair use, for commentary, scholarship, education. And definitely criticism.
Shard copied on that email. Mr. Mel.
Now for all of the extraordinarily important people. Ms. Knight, good morning. All right, Mr. Kokomo, good morning. Ms. Hallwinger, good morning. Mr. Mansbach, good morning. Who?
Jack Pond. He was yesterday.
No, it wasn't. You had another woman.
That was day 4.
Okay, so don't be trying to trick me, man. We're trying to trick. Oh. Pines. Is he related to the other Pines?
Yes, this is Noel Pines' son. Nice to meet you, Your Honor.
Your father is a fine lawyer. I've known him for many years. So why are you sitting, in court? Yeah. So. Yeah, and there's some other. In there. Did your father kind of, say, hey, you need to see some other lawyers or what? That happens. Well, welcome, sir. All right. Okay, and Mr. Botts, I understand you have a handler this morning? I just say you go get some classes. And who do you have, sir? Hi, good morning, madam. Welcome. Okay. All right, please don't let him get up too much, okay? If he starts to talk, just... Okay, all right. Okay. All right. Anybody else I fail to recognize? Okay. All right. All right, Deputy Avila, all our jurors present, madam?
Yes, Judge.
All right. Before I call for our jurors, any issues I need to take up?
Yes, Your Honor. Your Honor, yesterday evening, the state received a email from John Melnick with Mr. Steele and Mr. Sharp copied on that email. Mr. Melnick advised that he represents our next witness in this case. Prior to receiving that email, the state had spoken with our witness on multiple occasions in preparation for trial. After yesterday at about 5 or 6 p.m., whatever time I received the email, he advised that we need to cease all communications with his client.
However, his client is?
Mr. Kenneth Copeland.
Okay.
However, his client is not, there's no open pending litigation. We were operating as a witness. And so Mr. Melnick advised, I don't know if he wants to be present or not, but that he had court at 9 a.m. before Judge Krause. And so I'm bringing that to the court's attention. The state did offer Mr. Copeland use immunity in this case, so that anything that he testifies to in this particular proceeding will not ever be used against him. Your Honor has signed that order. And so we are ready to move forward. However, I did want to bring to the court's attention that Mr. Melnick did advise that he was his attorney and that he was present in the building. I believe wanted to either address the court, but
okay, well, if he's inserted himself in that particular respect, he needs to probably be here. So can we send some?
Now, did you hear the judge say that if his lawyer was inserting himself, how does he insert himself when he is his attorney? I don't understand that, and I certainly don't understand how the judge now knows the man is his attorney and he doesn't ask about the conversation she had with his attorney before they offered the immunity. And maybe they can do it with the attorney, but it just seems something is off there. But okay, let's keep going.
somebody up to Judge Krause's to inquire? Because, or is he here? Or is he outside?
I have not seen him yet. So
Is Mr. Copeland or his counsel present?
Mr. Copeland is present in the courthouse. Yes.
All right. Where's Mr.
Judge, I saw Mr. Melnick this morning. I think he's in Judge Carnon's cell.
Oh, maybe it's Carnon's.
Okay, could we see if we could find him, please, and have him tell him that we're about to call his client?
I'm not sure if any of Mr. Charlemagne still has. I do not have his phone number.
Okay. Well,
And while we're waiting for that, I do have two other issues.
hold on, let me. Deputy Avila, can you ask one of your colleagues, or Deputy Ham, can you see if you can go up or have one of your colleagues go up to Judge Carnon's sales and see if we can, one, either get him down here, or two, ask Judge Carnon's sale when he would be available. And tell him that we also have a witness that we need to call, okay? All right, sir.
And then next, Your Honor, while we're waiting in that pendency, Mr. Copeland does have prior criminal convictions. The state did not see in any.
We might want to take those up if he's got counsel, okay?
Okay, well,
So,
I'll wait.
yeah, so let's wait till his lawyer is actually here, so we can take up those issues if he does have counsel, okay?
Yes, Your Honor.
All right. I'm just gonna recess him in place then. Sir?
Good morning. Can I just step out while we're recessing? Is that okay?
Yes, sir.
Good morning, Your Honor.
Good morning, sir.
So for the limited purpose of this issue regarding whether Mr. Copeland will testify at this trial, I am representing Mr. Copeland. Your Honor, I spoke with several individuals in the Fulton County District Attorney's Office before this case was indicted. And the Fulton DA's office was very well aware that I was representing Mr. Copeland. Apparently, they have had conversations with Mr. Copeland outside of my knowledge and presence. Now, I can't do anything about that because he talked to them without contacting me first. However, he did contact me yesterday and told me that he was being subpoenaed to testify here today. And I asked him what he wanted to do. His position had been and has always been that he wishes to exercise his Fifth Amendment privilege against self-incrimination. I have explained to him, and I learned this morning that apparently an immunity order has been entered under OCGA 24-5507, granting him use immunity for testimony at this trial. I would object to that proposition. And the reason is this. I know very well that the district attorney's office knew about my involvement in this case from the inception of this case. I spoke with Don Geary in 2021 about this matter. And he asked me whether or not Mr. Copeland intended to cooperate with the state. And what he told me is that Mr. Copeland would probably either be a witness or potentially a defendant in this case. I spoke with Mr. Copeland. We had numerous conversations between myself, Don Geary, and Thomas Greiner, who's in the Fulton County District Attorney's Office, who was prosecuting Mr. Copeland for a separate matter. And Mr. Copeland has steadfastly said that he intends to exercise his Fifth Amendment privilege. I have also participated in a conference call regarding a bond for Mr. Copeland when he was when he had an indictment in Judge Whitaker's division. Present in that conference call was myself, Adrian Love, Adam Abadi, Abby Potter, and Judge Whitaker. And we very specifically discussed the state's concerns about Mr. Copeland getting a bond in that case, given that the state wanted to utilize him as a witness in this YSL case. So, Your Honor, Mr. Copeland is here. I can state as his attorney that he intends to exercise his Fifth Amendment privilege against self-incrimination. He does not wish to testify in this trial. And I would ask, there is no other, he's not on bond, he's not on probation, there's nothing like that. I would ask that he be allowed to leave this courtroom without being compelled to testify.
All right. Ms. Hilton, do you wish to respond?
Yes, Your Honor.
All right. And Mr. Malik, you are correct. I did go ahead and sign this morning. I'll make a part of the record the court's order giving him use immunity. Okay?
Good afternoon. Good morning.
Just listen how arrogant he sounds. You know, that little... He just sounds so... He doesn't care. And why should he? When they're getting all of that money. Because that's what I believe all of this is about. The Orca money.
Morning again, Your Honor. So first, let's give a timeline of events. Mr. Melnick spoke of speaking with Mr. Don Geary. I would believe that.
What does it have to do? Let's cut to the chase. Okay?
So
I mean, all of that, it may be maybe historically.
Because I want to make sure the record is clear as to what Mr. Melnick said as far as his representation of him, especially as it relates to him being a witness in this case.
Okay, all right.
So
I'll let you fill in the background.
Sure.
Okay, go ahead.
So when Mr. Melnick, I believe, engaged with Mr. Geary, Mr. Copeland had at that time either two open pending cases, because this would have been in 2020 or 2021. At that point in time, he had open pending charges with the Fulton County District Attorney's Office. Since that time, those cases have been closed, and therefore Mr. Copeland does not have any open pending charges. Therefore, We have not spoken to Mr. Copeland previously when he had open pending cases. We have only spoke to Mr. Copeland as it relates to his being a witness in this trial. Mr. Copeland was subpoenaed a few months ago, but as we were getting closer to his testimony, we resubpoenaed him again last Friday, which was a week from today. When we met with him, we spoke with him briefly. I believe I asked him if he had an attorney or if Mr. Melnick was his attorney. I believe my understanding from Mr. Copeland was that he hadn't spoke to him or that he wasn't his attorney.
Now you notice everything she said she believed. And listen to how she makes sure she lets the judge know. She's assuming that this man was just his attorney when he had those pending cases. And after the pending cases went away, he wasn't his attorney anymore. But the lawyer specifically stated he was his attorney in this case here before it ever started because they wanted to use him as a witness. And so they knew all along that this man wanted to plead the fifth because that's what his attorney said. So that's why that other man said he's going to be either a witness or a defendant. And because they wanted him as a witness, then they decided that they wasn't going to let him be a defendant. They was going to make him a witness. All of this was planned. This is not by happenstance. But listen to her story and her reasoning and how she believed what, not what was said. She didn't record what was said. They didn't take any notes. This is just her belief.
At that point, we continued to engage in conversation. Mr. Copeland engaged with us. On Monday, we reached out to Mr. Copeland to see if he wanted to come down to do witness prep. We did not meet on Monday. On Tuesday, we thought that he was going to get called. He came down here. We spoke. He asked us questions. We answered his questions, and we moved forward. At no time during any of those conversations that we had with Mr. Copeland that he advised that he wanted his attorney there. We would have obliged that, but I believe that we were having good conversation as he was a witness in our case. Yesterday at our final prep session, we spoke with him. It was about 1 o'clock in the afternoon in the courthouse. When we left the room that we were meeting in, I saw Mr. Matt Shard in the hallway. As we left, we had our greetings, and then it was not until 6 o'clock last night that I received an email from Mr. Melnick, copied Mr. Shard and Mr. Steele on that email, and advised that his client was going to plead the fifth. In the state's conversations.
Oh, y'all probably can't hear it because I didn't cut the mic back up. I'm sorry. But so y'all didn't understand her when she said she saw Max Short in the hallway, which has nothing to do with what's going on in this courtroom. But she said that to say after he saw them talking, he contacted the lawyer. I know that's what she's saying. I'm sorry about that. That's why you couldn't hear it good.
With Mr. Copeland, he had some concerns, and we had told him just in general conversation that we would give him use immunity to testify in this trial. In the trial. Once we received the email from Mr. Melnick last night, we moved forward, Your Honor, drafting a motion in order to give Mr. Copeland use immunity in this case. 24-5-507, Your Honor, lays out that it is the state's purview in order to give use immunity because it's only the state that brings charges in this case. And we have decided that whatever Mr. Copeland says, he will have immunity in this trial and in this proceeding. And that has been the state's decision, and the state can make that decision. And we have so done that pursuant to 24-5-507. And furthermore, Your Honor, if Mr. Copeland does not testify, he could be held in contempt. We had that conversation with him as well, that he could be held in contempt if he does not testify, Your Honor. And so the state would ask that the order that the court has signed be honored, and that Mr. Copeland be compelled to testify and not insert his Fifth Amendment privilege and testify as a witness in this proceeding.
May I respond, Judge?
Yes, you can, Mr. Miller. So, Mr. Melnick, here's the thing. Your client can certainly advance his Fifth Amendment privilege against self-incrimination. I have signed the order under 24-5-507. So I guess have you explained to your client the potential second and third order effects that could occur depending upon his decision?
I have, Judge.
Okay. All right. I guess the only thing to do at this point in time is to bring him in and determine whether or not he would like to make sure he understands
I understand.
where he is under 24-5-507.
He is present in the courtroom, Judge.
Okay.
What he has told me is that he repeatedly told the DA's office that he did not wish to cooperate, did not wish to testify, and wished to exercise his Fifth Amendment privilege. But I can bring him up and have him state that on the record.
Yes.
Okay. Come on up, Mr. Copeland.
Mr. Copeland, come on up and have a seat here, sir. No, he doesn't need to be sworn in. Yeah, no. All right, Mr. Copeland, your counsel, Mr. Melnick, have you had an opportunity to talk with him about testifying today?
Yes.
All right. Has the state provided you a letter of immunity or a copy of the order that I have signed directing that they give you use immunity?
Yes.
Do you have a copy of it?
Yes.
All right. Can we see that, please? Can I need 2 copies of it. Actually, 3.
Your sign.
Not yet, sir. Doesn't apply to you yet, Mr. Steele. But it is going to be part of the record, Mr. Steele. I haven't filed it yet under Odyssey. I don't think it's made the Odyssey system quite yet. So, anyways. Huh?
We have a proposed order.
But I signed the order this morning, though.
I meant the manner in which it will be filed will not be made public.
Okay. All right. Which copy's been given to Mr. Copeland? The order pursuant? All right. All right. Do we have extra copies of that? Mr. Copeland, I'm going to mark this as the next court's exhibit in order, okay? Mr. Copeland, can you take a look at that order for me, please, sir? All right, let's just go through it right quick, okay? I just want to make sure that you understand where you are and you have your attorney here. And if you have questions of the court or your counsel, you can go ahead and do that, okay? All right? You have to answer yes or no, sir.
All right.
Okay, all right. I'm not trying to trick you. I'm not trying to do anything other than explain this to you, all right?
Okay.
Okay, all right. Mr. Copeland, this order reads basically, the state of Georgia has moved the court pursuant to this particular statute, which is 24-5-507, to compel your testimony, and our district attorney, Ms. Willis, having determined that your testimony is materially as necessary to the public interest. And that is, and if you take a look at the footnotes, sir, I'm sure your attorney's probably explained this to you, that she has the purview of determining whether or not your testimony is needed for a particular trial. I don't even have that authority. Your attorney doesn't have that authority. You can't decide that maybe it's not really necessary. She makes that decision. So, and it's in the public interest. So you've been subpoenaed in this case to appear before and give testimony in this particular matter. And the state has provided the court sufficient reasons as to why you are necessary as a witness in this case. It appears that you've been properly subpoenaed to appear as a witness in this case, and that your testimony is necessary in the public interest. So that's how we, as a due process, gets you to come to court. I mean, you were noticed as a witness. They've identified you as a witness. They've determined that your testimony is needed. Because of the fact that you have some concerns about what your testimony may indicate or could indicate in this case, and that's something that you and your counsel have talked about, and I'm not certainly going to inquire about that. But in order to potentially deal with anything that may come out of that, the state is basically, knowing that you have a Fifth Amendment privilege, says, okay, we acknowledge that. We're going to give you immunity. And as a result of that, then you have to testify as a result of that. If you don't testify, then I, as the judge in this case, have several remedies. One of those is that I could hold you in contempt and jail you because the way that you get out of that contempt is to just testify. That's the only thing they wanted in this case, for you to testify. So your attorney told me you're going to invoke your Fifth Amendment privilege. Done, said. However, the immunity has been signed. I have a copy of that right now. So you're required to testify. So if you don't testify, the state's probably going to ask me to jail you. And I'm probably going to do that. So I'd like you to go ahead out and talk with your lawyer and tell me what you want to do at that point in time, okay?
Do you need any more time to talk, Mr. Copeland? Okay. What is your desire at this time?
I'm taking the fifth.
Okay, you're taking the fifth, but you've got immunity, but you still want to, are you going to testify? That's the thing.
That's the question.
That's the question on the floor. I've acknowledged the fact you have a Fifth Amendment privilege, but the state's giving you immunity, so that overrides that Fifth Amendment privilege. They require you to testify.
Yeah, but the state don't know what you're talking about. So they ask me a question. They implicate me. Then
Okay, they can't prosecute you on that. They can't. The order prohibits them from allowing them to use that testimony against you. That's what your lawyer, and I'm not going to get into any of the machinations or intricacies of what may or may not have happened in this case, but Mr. Melnick is a very seasoned criminal defense attorney. I've seen him over the past 2 decades. I'm sure that he's probably given you very, very good advice, but the state can't use that testimony. They can't kind of say they have it both ways, like you testify and then use that against you to indict you and prosecute you. Then we wouldn't have any faith that we need to have people come in and give testimony. So that's why they can't do that. They kind of can't go back on what they're going to tell you, So I signed the order. Now they've asked for immunity. I've signed the order. So basically, whatever you have to tell us, you'll tell us.
say no more.
Do you wish to testify, Mr. Copeland? Is that no? You have to say no on the record.
Say it again.
Do you wish to testify?
He said I can tell him whatever I got to tell him. So I testify.
You will testify.
Yeah.
All right, sir. Okay. What we're going to do in just a second is I'm going to go ahead and I'm going to call for our jurors. We'll formally administer the oath to you, and then the state will ask you some questions, okay? And then you'll be cross-examined at some point in time by potentially...
Can I speak to my attorney before? Because I think I just said the wrong thing.
Sure. I'll tell you what, why don't you step outside and talk to Mr. Melnick. Come on up, Mr. Copeland. All right, sir. What's your pleasure?
Say what?
I said, what's your pleasure, sir? Do you wish to give testimony? I know you don't want to give testimony in this case, but you've been given immunity in this particular circumstance, use immunity. So are you going to testify?
Yeah.
Okay. All right. All right, sir. Then what we'll do at this point in time is we'll call for our jurors and we'll swear you in. And we'll go ahead and take your testimony, okay?
All right.
All right. What is it, Mr. Steele? Does our witness need to be excused? Yeah, sir, go ahead and stand outside, please. If you wouldn't mind, we'll call you in just a minute. All right. Mr. Copeland has left us. Yes, sir. What's your pleasure?
Good morning, Your Honor. Good morning to everyone. Your Honor, I would like the court to weigh in on this, please. I would like it now. That's why I raised it. But if you do it on a break, that's fine. I mean, whatever you want. But I'm citing to the court two cases, if you don't mind. Franklin, which is Franklin, like Donald Franklin Samuel, versus State. It's 166 Georgia Appeal 375. Yes, of course. 166 Georgia Appeal. .375. It's in Division 2P versus Head, like Bubba Head, and that's 279 Georgia. 826, that's Division 2. It's Roman numeral 2A, capital A. 620 Southeast 2D2. But that's wrong. 829 2005. And Your Honor, what I'd like you to do is the state has stated today, and Ms. Hilton told me this last evening. I don't remember the time, but maybe 6 o'clock, 7 o'clock, something like that. We had 2 telephone conversations. She said that she's met with Mr. Copeland and other members of the prosecution team. I asked for any notes that were entitled to exculpatory information under Brady. Ms. Hilton told me that there was one statement, and she emailed that to me and to everyone on the defense side. But Your Honor, I don't have any of the other notes. Mr. Copeland met with law enforcement on the January 11th of 2015. So God forbid the killing of Mr. Thomas is at 7:22 approximately January 10th, 2015. By the early morning hours, I'm going to tell you about 4 a.m, Mr. Copeland is on video audio recording with Detective Thorpe the next morning. So it's January 11th, 2015. And he made statements that he knows nothing about anything. Since then, he has made additional at least 5 recorded statements that I'm aware of, and he's made other statements that I have nothing on. Anything that, and he's been inconsistent. So anything that he told the state in this preparation would be inconsistent statements, which is impeachment evidence under Brady. And the state, I presume, will claim work product. That's why Ms. Hilton didn't give us any of the notes. But work product of the state is typically not subject to compelled discovery, except to the extent that such notes may be exculpatory and must be disclosed under Brady versus Maryland, which is 373 U.S. 83. Well, that's under Franklin. And then Walter versus Head says that work product doctrine gives way to the accused constitutional right to exculpatory and impeaching evidence under Brady. So what I'm asking this honorable court to do is order the state to produce all notes. They investigate. If they don't want to do that, I ask the court to get a copy of the notes in camera inspection and then meet with us ex parte so we can tell the court what we believe would be inconsistent statements, which is impeachment. That's why I brought it up to the court. All right.
Your Honor, as I discussed with Mr. Steele last night, I turned over the statement that I believe was Brady, which was what Mr. Copeland told me about an incident in which there was a theft. And I provided that information to defense counsel. Outside that, the state doesn't have any notes. And so there's nothing else to turn over except for what I did turn over. We do have one additional matter, Your Honor, which would be criminal convictions that I would like to address.
Okay, let's deal with the issue first, the first issue of the notes, okay? Do you have any written notes from your interviews of Mr. Copeland? What Mr. Steele is basically saying is that Mr. Copeland's given a few, he said 5 statements, and that some of those may be inconsistent, which would fall into the category of Brady, or may fall in the category of Brady. So do you have any written notes that you or your team took that arguably would be work product, but that I would need to review to determine whether or not they are on Brady.
We do not have any written notes on.
All right, Mr. Steele, then that satisfies that issue in terms of that. If I find out that there's any other additional notes, then I'll change the terms of my consideration on that issue.
Your Honor, and I'll get you the case in a moment because I don't have it at my mind unless someone else does. But oral statements must be reduced to writing if they're Brady by proxy.
Yeah. But I think they're saying to you that the only statement that they have that's Brady is the one statement they turned over already.
And Your Honor, furthermore, in addition to that, in our conversations with Mr. Copeland, he didn't give us any different information than what is contained in the 6 interviews that defense counsel has had since 2022. So there's, outside of this one sentence or this one piece of information which we gave, our conversations were not.
There's nothing. Are you telling me that there's nothing that that needs to be reduced to Brady?
Correct.
Reduces Brady.
If there was, we would have reduced it and sent it over.
All right. Okay. All right. Let's talk about prior convictions. Where's Mr. Melnick? Can you have him come back, please?
Shown me a
Okay. All right. All right. Can we summon our participants, please? All right. Summon our jurors, please.
Wait on one yard.
Right. All right, ladies and gentlemen, please be seated. All right, thank you, Deputy Ham. Ladies and gentlemen, the jury, good afternoon. All right. Without further delay, we're going to go ahead and call the next witness. State.
Your Honor, Ms. Hilton calls Canon Copeland to the stand.
All right, summon Mr. Copeland, please.
Your Honor, here is that.
Now, I don't know if you saw that look when she went to tell Your Honor, but listen to how Your Honor stops her from talking to him.
Mr. Copeland is.
Here it comes. All right, Mr. Copeland, go ahead and approach the witness stand. Before you sit down, if you would turn and face Deputy Hand be sworn as the witness.
You swear affirm testimony to get report the truth, the whole truth, nothing but the truth, sir?
Yes.
Maybe see, you state your first and last name, but spelling both, please.
You say that again?
State your first and last name, but spelling both, please.
Kenneth Copeland.
Mr. Copeland, do me a favor, pull your chair up as close as you can to the microphone and speak directly into it so we can all hear you. So if you could state and spell your first and last name for the record, please.
Kenneth Copeland.
Spell it, please.
Kenneth Copeland.
All right, thank you, sir. All right.
And Mr. Copeland, good afternoon. Do you want to be here?
Ma'am,
Do you want to be here?
I'm here.
Okay. Wait, are you going to let me ask you some questions?
Okay.
How old are you?
Grown.
Okay, what does grown mean?
I'm an adult.
Okay. And when you say you're an adult, what number in years are you?
I plead the fifth.
Ladies and gentlemen, can I get you to step outside to your headquarters of jury deliberation, please? From
All right, sir.
All right. Ladies and gentlemen, please be seated. Our jury has left us. Mr. Copeland, given the fact that you have invoked your Fifth Amendment privilege, but the state has already given you immunity under 24-5-507, this court holds you in willful contempt, and we'll see you on Monday. And we'll see if we can get some more testimony at that point in time. Take me into custody. All right. State, do you have any other witnesses you plan on calling this afternoon?
No.
Oh. Okay. What I'm going to do is I'll call our jury and tell them that you're going to be in recess for the weekend, and we'll come back on Monday.
And then, Your Honor, the jury is excused. Would you please entertain a motion for mistrial?
Mr. Steele, I'll entertain it right now.
I didn't want to hold the jury, but that'll be fine.
And what's the basis for your mistrial? We didn't know he was going to invoke.
The judge is not a team member of the state. And he said, we didn't know. We didn't know what he was going to say. Who is we? And he's the referee.
We didn't know what he was going to testify to, and I certainly didn't let him. He was only asked one question. So at this point in time, there's really, I mean, you can't knowingly let a witness invoke their Fifth Amendment privilege in front of a jury, but that didn't happen in this case. Last thing we heard from Mr. Copeland was he's going to testify.
So everything you say, I'll adopt because I was about to say those words. Based upon information belief, I'd like to call witnesses from the prosecution. I was told, I do not have the personal information, but I was told that Mr. Copeland made that known to officers of the prosecution team prior to being called right now.
But it's what I was told. I mean, the last thing the court knew, and he has counsel.
If a party knows that a witness is going to invoke the Fifth Amendment in front of a jury, which poisons us, I mean, there's no doubt it prejudices Mr. Williams et al., all of them, because this trial's been going on now, I believe, 8 months in front of a jury, and they've heard Mr. Copeland's name however many times a court reporter says.
Casey, that's what we've heard.
No,
so
the jurors heard Kenneth Copeland.
And as well, okay.
I opened on him that he's a killer. We cross-examined all these witnesses about Kenneth Copeland. The state talked about Kenneth Copeland. My point is, if this honorable court finds that the state knew or had reason to believe that he was going to do this in front of a jury, that his response was going to be, I'm invoking the Fifth Amendment, then, Your Honor, yes, I adopt what you said. That's wrong of a party, and I'm moving for mistrial.
Okay.
Okay.
All right, sir. Thank you. All right. Yes, sir. It would apply to everyone. Yes, Ms. Love.
Your Honor, I'd just like to put some things on the record
Sure.
regarding Mr. Copeland. As we stated earlier, Mr. Copeland has...
I don't want to interrupt you. Your Honor.
Anybody in the chat, let me know if you can hear this. I'm going to not share the video. I'm just going to share the audio. So y'all heard her say the building blocks start with Mr. Copeland. So that's why they want to start the actual frame, meaning framing the defendants with Mr. Copeland. Everybody else was just leading up to this. And without him, then they have no case and they can't keep making up stuff. I'm sorry for those who just looking in. I'm not going to be able to share the videos because it keeps buffering a lot. And I don't know why. I bought an Ethernet, but it's not doing what I thought it was going to do. So until I can figure that out, I'm just going to allow y'all to hear it because I wanted you all to go back to how the judge sounded when he talked to Mr. Steele and Mr. Bott, how rude he was, because I'm going to share with you guys in just a moment the contrast since the Supreme Court stepped in and sent it back down to the courts. And I want y'all to hear one, and like I said, it's been a famous one because other people have been playing it, and that's the lawyer you know and his dad. I want to play them so that you all can hear. They're going to go through that transcript, and you can see that it has some missing pieces to it, and you need to hear these things so that you can kind of understand what could be missing. So I'm sorry for the inconvenience, but that's the best way I can do it. Now, she just said in open court, the state has a matter we need to take up ex parte with you. And he said, okay. So that leads me to believe it was two meetings. They had one that evening when the other people were in there meeting with their clients. He was meeting with them. They said it in open court. So he has the right to have meetings on something that's pertinent to their case, but not to the case. Like if they want to change scheduling or something like that. But they can't discuss their strategy and how they're going to do this case. So that's why I believe that that wasn't an issue. And that's the end of that. So I want to get down to how he talked to Mr. Steele when Mr. Steele told him that he heard about their meeting that they had. The ex parte meeting. I just need y'all to hear this so y'all can hear the contrast in how he sound when he was talking after the Supreme Court spoke.
Adrian Love, stating that Mr. Melnick does not represent the witness, and that Mr. Melnick wrote an email saying F you, and then somehow that email was CC'd. To me, that never...
Mr. Steele, can I interrupt you just a second? I'm kind of disturbed because that's ex parte. All that was an ex parte conversation. How did you find out about any of that?
Well, I'm disturbed too. And the reason
I'm asking you a question. How did you find out about it?
I'm going to ask you the question.
Okay.
Scuttle, if you look at SCUDDER versus state, which is 298 Georgia, 438, it's Division 2, 782 Southeast 2D 638, 2016. Our highest court says when a court meets, because Mr. Copeland comes in, meets with the court supposedly made statements, which I assume is somehow accurate based upon what you just said. We're entitled, Mr. Williams and every other person wrongly charged here is entitled under the Georgia Constitution to be present. That's a critical stage.
It's just like when you meet with me, and you and Mr. Adams meet with me, and others have met with me. It's those were ex parte for a lot of different other reasons, but I will certainly note that for purposes of record.
Well, I'm going forward. What I was told was that Mr. Copeland said...
And you haven't answered my question yet.
I'm not going to answer that question.
You're not?
No, I will not answer that question.
Why will you not answer that question?
Because I want to make sure that what I say is accurate, and I'm not trying to...
No. I'm asking you, how did you get this information?
I'm not telling the court. What I'm saying is based upon information...
Okay, well, listen, if you don't tell me how you got this information, then you and I are going to have some problems.
We can have this... I have problems right now.
Okay, I know. Look, I don't want to know about your problems, okay, at this point in time. All I'm asking you at this point in time is, how did you come upon this information? Look, if the case gets reviewed, the record's going to be available for our appellate court and for whatever reason. But it's disturbing that how somehow you have surreptitiously gotten information in regards to the court's private ex parte conversation with a party. I mean,
a witness who was sworn in Friday, the court's telling, this is what I was told. If this is not true, not true. This court handed Mr. Copeland...
Tell me how you got the information.
Listen, whatever you want.
Tell me how you got the information, then we can go ahead and go forward.
I'm not going to say that. What I'm going to say is this. I was told, and I hope this concerns the court.
It concerns me that you have proprietary information.
Why is it proprietary?
Or information that you should not be having that was ex parte.
Why?
With a party.
Why?
State of Georgia.
How about the witness? How about Mr. Copeland, who supposedly announced he's not testifying and he'll sit for 2 years, and then supposedly this honorable court, or excuse me, let me rephrase that. This court supposedly said, I can hold you until the end of this trial. Ms. Hilton supposedly said, actually, all of the defendants and then all 26 people are disposed of. If that's true, what this is coercion, witness intimidation, ex parte communications that we have a constitutional right to be present for. So I understand that you're upset towards me, but I don't know what I did.
Mr. Steele, I still want to know, how did you come upon this information? Who told you?
What I want to know is, why wasn't I there? Why,
sir, I'm going to hold you in contempt if you don't tell me who tell me who this information was from.
I don't want to be held in contempt. Well, I'm not answering that question. That's attorney-client privilege information. I am not
attorney-client privilege. Unless you were in my chambers, that's the only way you can figure out.
I am.
I tell you what. I'm going to give you 5 minutes. If you don't tell me, if you don't tell me who it is, I'm going to put you. I'm going to put you in contempt because. That is not attorney-client privilege.
Attorney work product privilege. I am not.
How did you get that information supposedly from my chambers? Did somebody tell you?
I'm not. You should have told me.
You got 5 minutes.
Well, I don't need it. I want to continue.
You got 5 minutes?
This is what I was told. Mr. Copeland made statements that he admitted to killing Donovan Thomas and was. Don't take my notes. No.
like when you asked me for an ex parte conversation.
I've never asked this honorable court or any court to meet with me and a witness.
Sir, you're straying off the issue.
I'm not.
The issue is how did you get this information?
I understand the issue. I promise you, I understand it. But what I'm trying to ask you is, if you look at comment 5, this is how I understand the law.
You cannot you can't violate something and then use privilege. Okay?
I'm not violating anything.
Okay, but that's why I'm saying, how did you get the information?
But just listen to what I'm trying to tell you. You're saying,
you're
threatening me with contempt.
Privilege would occur. The privilege in 1.6 would occur if you were in the right place, right time to begin with. You weren't.
Let me tell you, I'm just reading from it. But if I'm reading it wrong, I'm not trying to. It says 1.6 applies not merely to matters communicated in confidence by the client, but also to all information gained in the professional relationship, whatever its source. So you're asking me to break, you're ordering me, maybe, you're asking me, I'm not saying you're ordering me, but to give you information, and you're saying it's not substance, but I'm telling you, I can't do that under the bar rule.
All right, well, I'm going to hold you in contempt. And you can think about it. 5 o'clock today, we'll see where you are at that stand on that point. Because no, that's not what I understand the rule to be. I've not asked you some in substance of what was said. I asked you how you got it.
I can't do that.
Yes, you can, because I have an idea how you got it.
Well, your idea.
I have an idea how you got it, but that's improper, sir.
Your idea may be wrong, and you're asking me to. Listen, I told you the first time, and I'm not sure.
I don't want to hold you in contempt, but this is that serious.
Judge,
you cannot eavesdrop and get information that was not meant for you to hear at that particular point in time.
Judge, listen, and listen. I'll do whatever you want.
I don't know if y'all can see this or hear this, but I'm having a real terrible time tonight. I don't know why. My Ethernet said it's working, but this computer seemed to be doing some weird stuff. So I don't know. Can anybody tell me that you can hear, or you can't hear, or you can't see what's going on? I had taken the video down and just was going to play the sound because it keeps buffering so much. And it doesn't buffer when you play the sound, but I wanted y'all to hear how bad he was talking to Mr. Steele before I played the young man and his father, and you hear how humble he has gotten. And then I had 2 other little ones I wanted to play that say you can tell how this transcript was redacted. And so I don't know how this is going to turn out because it keeps messing up, but I thank y'all for staying with me, and all of y'all that come and go. I greatly appreciate it.
To 5 o'clock or thereafter. But what I'm trying to tell you is, Your Honor, this is so serious to me. We need a hearing, and I'm moving for a mistrial. It is my understanding, based upon information belief,
from whom?
Part of it.
From whom?
Well, I'd like to get the substance first, and then we can.
Okay, well then you'll be in custody until then, because because you need to tell me how you got the information. I'm not asking you what was said. You've already kind of given us some snippets of what you said. That tells me that somebody parroted that information to you. So,
but you're assuming something because I told you already.
Well, then, other than if you were sitting, unless you were sitting in there with a recorder, or Miss Love or Miss Hilton, or one of the deputies gave you that information, or Miss Weaver shot you a rough copy of the transcript, there's only one other person that's left.
Well, Your Honor.
And if that person gave you that information or shared that information with you, she probably violated privilege.
Well, let me tell you 2 things. One, I don't know how that as a privileged communication. It shouldn't have
Well,
been.
it's because she has a client she's supposed to represent.
Who are you talking
But
about?
anyways, I'm not going to have a.
When I got this information.
I'm not going to have any further conversation with you about this. I want to know, the question still remains. I want to know who gave you the information?
I'd like to know what information happened outside our presence. That's really it.
He can go into custody at this point.
I think that the court needs to again declare a mistrial based upon.
Okay, and I'm going to deny your motion. I'm going to deny your motion.
I understand that you spoke with a witness outside our presence.
And whenever, yes, I had an ex parte conversation, which is appropriate.
And you influenced the witness based on information belief, and I'd like to have that all on the record.
All right.
I mean, I don't know why that's so hard to do. If nothing happened bad, that's fine. But you're acting like, tell me who it is and don't talk about the substance. Why can't we have an issue that was outside of presence? It should not have been.
Because you got some information that you shouldn't have gotten.
Why?
Well, that's for another day.
But why?
Okay?
Why
that's for
did we
another
exclude
day.
in the first place? I didn't know about this stuff.
That's for another day. So
I raised it as soon as we found out about it.
Well,
I gave you the case I'm relying on. I assume you read it. If you didn't read it, you should read it. It's a material part, a critical part of the case. When a judge speaks with a witness outside the presence of the accused, the court has said it's right there in Division 2.
Okay.
That is a material or critical part of the case, and it's an automatic reversal.
Mr. Steele.
But you're acting like it's
Mr. Steele, that is not that is not the case when somebody discloses information in a ex parte conversation that one of the parties lawfully asked me to hold.
You're not supposed to have communication with a witness who's been sworn. You know that I'm not telling you. I'm just saying if you read I'm assuming you read it. That's what it says. And you did it.
Does the state wish to be heard?
You said it supposedly.
Yes, Your Honor.
And what I'm trying to get to is why did that happen outside of presence? And I need to have I'm respectfully requesting the transcript that you mentioned to be given to us so we could really understand it. And then anything that was not on the transcript, if anything, that we understand what happened outside our presence.
Okay.
And now you have put it where somehow I have to reveal, and I told you the first time, I'd be breaching 1.6. And I know you're assuming something.
I don't think you're breaching 1.6. You can't hide behind 1.6.
I'm not hiding behind anything.
You can't hide behind, yeah, but the thing is, I think you got this information. Somebody disclosed it to you, and that's the only way you could have gotten it.
What I got.
Because unless you're sitting there, you're eavesdropping. So you can't use something ordinarily that you had no business getting to begin with, and then stand on, well, hey, we didn't give you the information, or a party didn't give you the information. So,
Your Honor, but that's the issue, isn't it?
Well,
why aren't we?
that needs to be told. But
right now, we don't know
Mr. Steele,
why we were excluded from that.
Mr. Steele,
and I want that information because Mr. Williams' constitutional right under the Georgia Constitution.
Just stop at this point in time, because
Article 1,
because you've already said that. You've already said
Georgia Constitution, and we have the right to be present.
All right, Mr.
And we're not waiving anything.
Yes, Madam, Ms. Love.
And Your Honor, excuse me, and I know I said this previously.
Yes, sir.
But we are not accepting any proffer from this law.
Okay, excuse me.
Okay. All right. Yes, ma'am.
Your Honor, I am disturbed by Mr. Steele's representations to the court. The court has inquired. We have no way of knowing what it is or who it was that disclosed information that was contained within an ex parte conversation. Not only was there an ex parte communication between that we requested as a state to be on record with the court, but there was communication made, I believe, to a person and his lawyer. I don't know that the
Okay, now what she's trying to allude to, and she's putting it on record now, and I hope y'all can hear me, and I hope y'all can hear her and see her. I could on my phone, but Phyllis says she couldn't. But she's alluding to they asked for an ex parte to be put on record with the court. You know, when Steele asked for the ex parte in open court, he didn't say that because it was in open court, just like hers was Friday. Like I said, they had 2 meetings, and now they're trying to make the meeting they had Friday be the meeting that they had Monday morning, which was the one in secret, when they invited Miss Bumpus and Mr. Copeland into the meeting with all of the other staff. When they met on Friday, all of that wasn't there. So she's pretending, she's just jaw-jacking is what we call it. She's just talking loud and saying nothing. And then she said that Mr. Steele was telling the court about something he heard, and she doesn't know. That ain't any of her business. She's not the court. She's just another attorney in the court. Yes, I did notice she quit coming to court because they are dead wrong. Now, I don't know what the courts are going to do about it, but if they did the right thing, and like I said, to me, Kelly, what's so sad is we as a people aren't outraged about this modern day lynching that's taking place. We see them railroading these young men. We see the injustices. And do we not get upset because they look like us? And we only get upset when they're European? That doesn't make sense. If you care about life in these young men, and you don't have to care about them as a human, well, as an individual that you know personally, but certainly as a human being, and knowing that you had a father, have a father, you may not have a brother, you may know a cousin, you may know an uncle, a friend, a spouse. You know, this is ridiculous. But this is how we get thrown in prison and forgot about it. Then everybody think because you're convicted that you're really guilty of what you're convicted of. A lot of these people are taking pleas that are not guilty. Some of them are guilty. They're giving them pleas and let them walk. But they say this is in the interest of justice. In the interest of whose justice? If you let the criminal go on a plea deal and incarcerate the ones that don't have records, doesn't make sense. It really doesn't. But I needed y'all to hear this, so when y'all hear him, when they go over this thing, and everybody is now doing the story, and they do it like they did over in the section I used to be in. To me, they're doing it all for the sensationalism and the donations, and they're getting the subscribers, the looks, and the donations. They're just pouring in like rain. But I promise you, myself and this guy E-Man Films posted, and then this young lady, I'm not a lawyer, but it's a young lady, Canon Williams. She's very good. She's kind of in that clique thing, but I don't think she's a clique. I just think that, you know, when they're all doing kind of something, they all pull each other in. So you go in thinking that people care and they want to help you and they applaud you, only until, you know, you outdo them, then that's when the problem comes. So that's none of my concern. I just want people to really get concerned, understand why we are supposed to be doing what we do, and we need to start fighting. And the best way we can fight this fight, because we're not in Georgia, is you can always file a complaint against the attorneys and against the judge. That's one right that we do have, and that's by way of the First Amendment in petitioning our government. And we just have to do what we can. And nothing may never happen. But I believe if enough of us wake up and start reading this stuff and understanding it, and that we don't understand, start looking up the words until we understand, I guarantee you some of this stuff will stop. Because we thought it would stop when the people that look like us get in office. But we see that's not true. It doesn't stop. They get greedy, just like these people on YouTube. And they only look out for their families. They care not about other people's families. And that's the sad part about it. These are women, and ungodly women, it appears. Ruthless women. Whew. But let me go back. I hope that y'all can hear this. And I don't know why this thing keeps buffering. I got the little Ethernet thing, so I'm going to have to call tomorrow and see what I can find out different about it. Because it's not doing what I thought it was going to do.
Reason that councils took the podium was to address that particular issue so much as it was to try and assert an inaccurate, what he calls fact, and put it out there in the open as if it were true. But we certainly have the right to request ex parte communications. That's why we asked that the court reporter be present. This is a matter that the defendants did not have a right to.
So then the question becomes, when did they ask that the court reporter be present? Because she asked for the ex parte conversation on Friday. And we heard her at the end of that other video. And she didn't say anything about the court reporter. So these people just lie right before your face. And Miss Love is really good at lying. You think that Mr. Copeland is a liar. No, this lady here is a professional.
Be a part of, as this was a matter regarding a civil contempt that the court imposed upon a person for not obeying the court's directive. The state read the case that Mr. Steele cited. It does not stand for the proposition he asserts that it does. And regarding further legal support for our position, we would provide that to the court, but we are more concerned that information that is disclosed in an ex parte setting gets relayed to the parties who are not privy to that. The whole purpose of the ex parte request was so that that did not happen. And we expressed on the record our concerns and our reasons for concern regarding that. We believe that without more information about how that information got relayed to the defendants, we cannot make the kind of assertion I'd be inclined to make. So before making the next set of assertions, I would need to know how that information was made privy to them, to counsels for the defendant. We did not act inappropriately or outside of the rules of professional responsibility. And if need be, we will reach out to the state bar ourselves and ask what the appropriate remedy is for everything that has happened over the last 2 days, well, the last 2 work days, because we are extremely concerned. We have observed a number of actions on the parts of a number of people that I am not comfortable stating publicly at this time, but that would appear to call for being addressed in some other way. So as to Mr. Steele's request, I guess it was for a mistrial. I'm not even certain what all that was. I think it was probably more to make inaccurate assertions on the record public to whomever was within listening shot of his voice. And we would ask that the court strike everything that he said from the time he stood up and started talking after the court asked him where it was that he obtained the information that was made privy in counsel for this court.
All right.
And regarding Rule 1.6, Your Honor, we read 1.6 as standing there. 1.6 in no way shields Mr. Steele's answer that the court requested he give. Rule 1.6 has to do with attorney-client privilege, and that is
these district attorneys don't even know the law. 1.6 has more than one point, and it's 1.6, I think it's paren 5, is where it talks about work product, and he read it. This lady is just talking, and this man ain't stopping her from saying nothing. It's just unbelievable. I made a complaint against him. I really got to go on and do mine against them two women. I mean, it may not do anything to nobody, but if we don't exercise our rights, we don't have rights. Oh, thank you so much, Kelly. I appreciate you. These people are just plumb crazy.
information that Mr. Steele obtained from his client regarding whatever matters. I don't know if the information was leaked to his client from someone who was in chambers, or if the information was leaked directly to Mr. Steele. In either event, it is concerning and in no way falls under the protections of Rule 1.6. If the court would allow me a moment.
All right.
Regarding further appropriate remedies, Your Honor, we would ask the court for an opportunity to further look into appropriate remedies for circumstances such as this, apart from what the court has already said, because it's grave enough when information is leaked from within the court's chambers regarding a matter that has been requested as ex parte, and we would ask for the opportunity to present to the court additional appropriate.
That woman is making it up as she go. I ain't seen nowhere where it's when something is leaked from the chambers of the judge in a matter of ex parte. This lady is just lying. And when you listen to the transcript for what they said they went in there for, his safety, they ain't talked about his safety. So this is just utterly ridiculous.
Remedies that we believe are available.
All right. Sure.
And Your Honor, also, unless it's Mr. Adams representing Mr. Steele in the capacity as someone who has been held in contempt, Mr. Steele just argued whatever it is that they are trying to argue based on information we believe illegally obtained from the court's chambers.
I represent Mr. Williams, and my statements are in regards to my representation of Mr. Williams.
All right.
He has two attorneys.
Okay, yeah, he does, but
The court now having found Mr. Steele in contempt, if the court continues in that position, that leaves Mr. Williams represented, at least at this juncture, by myself. That puts me in a position of making sure the court is aware that I'm in receipt of the same information that Mr. Steele received. I'm of the same opinion that the court has engaged in behavior that I believe compromises and corrupts the continuation of this trial. I do believe that we are entitled to and should receive a copy of the transcript so that a full investigation can be made as to what we believe has occurred here. And so I take the same position as Mr. Steele. I am asking for a mistrial, as he did previously, and I'm telling the court that I do not believe that we can proceed at this point based upon the information that we've received.
all right. So,
And frankly, I don't believe the state has any say in that. My statements are in regards to my representation of Mr. Williams, and if Mr. Steele is going to be held in contempt, I have exactly the same position. I also do not.
well,
believe
I asked him, so I didn't ask you.
Yeah.
So, but I'll leave it at that. Okay.
But wouldn't it be the same violation whether he asked him or not? He's not telling him, and he's not going to ask him, so he's not in contempt. Just tell me where that makes sense. This judge has been very, 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 very prejudiced against Mr. Steele, Mr. Shard, and to me, the one over there, I can't think of his name with the W, but certainly Mr. Steele and Mr. Shard, he's just been terrible, and he's been terrible with Mr. Matthews as well. This man is off the hook, and I don't know. I know he's the Brigadier General. They claim he used to do Veterans Court. Maybe he doesn't do it anymore, but maybe his disability has gone to the capacity that it's not serving him anymore, because I don't see how this man can sit before people and make judgments on their lives when he's suffering from such emotional disturbance as PTSD, and ain't no telling what other diagnoses he may possess. And we know that he gets upset real quick. He goes from 0 to 100 real quick. His understanding is bad, and he doesn't know the law. And that's scary. Very scary. We should be outraged as a nation, just as outraged as we were with George Floyd or anyone else. These boys, these young men are walking unalive. And we need to be outraged as a people. Everybody should be right. And I'll put the link in there. You can do what you like. A lot of people don't want to get involved. And it's not about that. It's about you. Because this could be you.
Okay.
Happy good guy.
What is it, Mr. Sharp?
Thank you, Your Honor. As you know, I represent Shannon Stillwell. On behalf of Shannon Stillwell, I am going to be moving for a mistrial, first and foremost. I just want to clear up a few things that have been said. Today, we were instructed to come 8:30 for a 9 o'clock start. I would not be honest with the court if I said I was here at 8:30, but I was probably here at about 8:40. We did not start till approximately, I'm estimating 11 o'clock. Clearly, we figured something was going on. We were given no information about any meeting, who was meeting, what the meeting was about, or whether the meeting was ex parte or not ex parte, who requested the meeting, who was in the meeting. We were completely in the dark. And quite frankly, we kind of remain in the dark. I am not a false accuser, okay? I do not just willy-nilly accuse people of things. So I'm not going to throw out spurious allegations like the ones that have been thrown at me over the past couple days that are absurd. But I will say, Your Honor, what I do know is just based on what we've heard over the last 20 minutes, it appears there was a meeting that I knew nothing about that involved Your Honor, the district attorneys, and a witness who had been sworn in. My client was not given an opportunity to be present at this critical stage. This was a critical stage in this trial. That error is a foundational structural error in this case, and it is the cause for an immediate mistrial. Additionally, Your Honor, I believe that this meeting, again, I'm going to ask for the transcript and I'm going to ask for the recordings as well, should they exist. But I believe that this meeting with a witness without us present may have made the district attorneys and or Your Honor a witness to this in this case. A material witness in this case. And finally, Your Honor, I'm going to ask for as soon as possible, I'm going to ask that these proceedings be halted until we can obtain an accurate final transcript for what occurred where none of the defendants or defense counsel were present for, and also the recordings of that meeting so we can see where we are. Again, I'm not going to sit up here and make false accusations or spurious allegations, but I do think we need to figure out what happened. We need to be in the know and not in the dark about what happened when a meeting occurs with a witness that has been sworn in. And we're not invited to the party. So those are my requests, Your Honor. I think it's necessary at this time to put a halt to these proceedings. I am moving for a mistrial. I have not waived anything. I just found out about this information. It is timely, and that's our stance, Your Honor. Thank you.
I've noted your motion for mistrial. It's denied. Okay, are you same thing? You want the Harvey?
Mr.
Okay, all right. Okay, Mr.
I'm adopting all of the statements.
All right.
Good afternoon, Your Honor. Carson Matthews here on behalf of Mr. Mark Williams Huey.
Okay.
We are also adopting all the arguments that have been made by
All right, sir.
Steele, by Attorney Pete Adams, by Attorney Max Sharp, by Attorney Douglas Weinstein. We also, Your Honor, we were here at the appropriate time. And when the court did come out, we were not made aware that there had even been an explanation that was had, that was on the record, just in the point of just letting the parties know that there had been this particular meeting. I had my suspicions that that was likely what was going on, but I could not reduce that to a fact. When the court came out, the court that based upon, again, ex parte, we don't have to know the substance all the time, but just the fact that there was that meeting, Your Honor, would have at least put us on some notice that there was something that was going on even beforehand. I thought that would have been the appropriate move, but nonetheless, Your Honor, I'm asking the court for a mistrial. I believe that it's appropriate here under these facts and circumstances. Thank you.
All right, motion for mistrial denied. Ms. T. Williams? All right, thank you, madam. Motion's denied. Mr. Gardner? Okay, so noted. All right. Okay, Mr. Steele, last time, who told you? All right, Mr. Steele's in custody. And once he clears the area, we'll go ahead and get started.
If by that point means we'll get started and resume the trial, Your Honor.
Yeah, we're going to continue. I'm not called nothing.
I'm not going to participate in the trial without the stealing.
You don't have that luxury at this point in time, sir. You don't. You don't have that luxury. You don't have that luxury at this point in time. You don't.
Without the court addressing the issue, we believe is germane.
Sir, you all are really getting yourselves cross purposes at this point in time. Sir, I'm telling you, you are at this point in time. You made some things out of nothing. I think that you're on very precarious ground at this point in time. So I'm telling you at this point in time, he's in custody. We're going to go ahead and start. You can represent Mr. Williams. That's okay. That's fine. I'll take up the other stuff as needed, but I'm not going to take it up right now.
I will not.
Say again?
Respectfully, I will not. I cannot.
Sir, you have to. Well, you're going to have to do the best you can at this point in time, because you don't get to extort the court. That's what you're attempting to do at this point in time. Sir, yes, you are. What you're trying to do is, I'm not going forward if I don't get this. You know, it doesn't work that way, Mr. Adams. And I'm telling you at this point in time, I would just kind of govern yourself accordingly. Sir, I'm telling you, as the court, under these particular circumstances, everything will come out as it should. I don't think. Sir, I don't have enough information at this point in time to address it. I don't. But I'm telling you at this point in time, there is nothing that was given, said, whatever this morning that.
If there is any accuracy to some of the information that we are.
But sir, I don't even know. Your co-counsel won't even tell me who said whatever. Okay. And the challenge I'm having in this particular circumstance is that is such a violation of the sacrosanctness of the court's chambers and an ex parte conversation. You're just glossing over that. You're glossing over that in its entirety. No. It's not, sir. Sir. That's not what happened. That's not what happened. That's not what happened. I'm just telling you, that's not what happened.
Judge, respectfully, we are not obligated to simply accept that there's been no violation. We believe that there has been, and the only.
Okay, well then no, we're not doing that at this point in time. So you'll have a choice to make. All right, take Mr. Steele into custody, please.
Your Honor, would the court afford me one moment to confer with counsel regarding the appropriate remedy in this type of situation?
Okay, all right.
May I say one thing, Your Honor?
Yes, sir, you certainly may.
Mr. Williams does not wish to go forward without me being here. You are removing me against his will, my will. You're taking away his right to counsel. And you're conducting material parts of this trial without me present, and I can't learn about it by watching online. So for that reason, additionally, I asked for a mistrial. And I assume you denied, but I'd like you to deny our motions for mistrial. You denied the other people.
I denied your motion, but I'll certainly take that under advisement, sir. However, and that's why I kind of want to know who told him that. So all right, ladies and gentlemen of the jury, how you doing? All right, listen, it's as you can see now, the hour is almost 6 o'clock. Is because of the way this information was disclosed. Have an attorney that's here for you, sir?
Sure. Ashley Merchant is here. She's the president.
Okay, all right. Well, we'll let Ms. Merchant in. That's fine.
Ashley Merchant.
Yeah, Ashley Merchant.
Ashley Merchant, yes. Right, Ashley Merchant is present.
All right. Ms. Merchant, good to see you as usual. I have told your client, you represent Mr. Steele, is that correct?
Yes.
For the purposes of the contempt. I've entered the order. I've entered the contempt already. I'm entering the order. I'm about to enter the order. I've held him in contempt earlier from today's proceeding by him not telling me who it is he got this information from. I'm not asking him for any of the sum and substance of the communication. He's been disclosing that, however, and that's why I kind of want to know who told him that. So if he tells me who it is that disclosed that to him, he will be able to purge himself of that contempt, and he's done. That's the only thing I'm asking for at this point in time. If not, then as you well know, as a criminal contempt, there's no supersedeas bond, there's no appeal, and I'm going to put him in custody for this evening. And if he wishes to, which he can still purge if tonight Keith Adams emails me or you email me and tell me, well, it was X. So I'm going to give him as much flexibility to purge himself of this contempt. Only thing I want is, because of the way this information was disclosed, it is troubling to the court, and it's very, since it was a ex parte communication. Won't get into the merits of everything else that Mr. Steele has proffered and everything else, but that's the only thing I'm trying to do at this point in time. So I've asked your client for the last time if he would tell me who it is that disclosed that information.
Judge, can you come up to the microphone? Sorry.
Please. Microphone, it'll pick up, madam.
Thank you so much. Just for the record, Ashley Merchant.
Which one?
It'll turn green. Yeah, it'll turn green. Yes, ma'am.
Is it on now?
Yes.
Okay, great. Thank you. Judge, just for the record, is it criminal contempt that you held him in?
Yes, ma'am.
Okay, and you said you had a hearing earlier today.
With criminal contempt, I told him what the contempt was, and that was he refused to tell, order of the court. If counsel, as you know, if the court orders you to do something and you don't, that's criminal contempt. So I've asked him several times, please just tell me who it is that told you. I didn't ask or inquire about anything that was said. I just want to know who it was. Because he's got too much detail of this particular alleged conversation for the court to be concerned about it. So,
and Judge, since it is a criminal contempt, he is entitled to due process. He's entitled to a hearing, entitled to an actual show cause, entitled to the allegations actually written, entitled to a witness list. We're entitled to present our own witness list and notice of that.
Criminal contempt is different. It is on the spot. So he's gotten the due process he's going to get. That's on the spot. I told him. Plus, he's had all day to tell me who it is that Is it so? A little different, Ms. Merchant. I won't disagree with you, but
Well, and
okay.
Judge, just for the record, it's that's direct. So what you're holding him in is in direct criminal contempt.
Yes.
The issue with the direct criminal contempt is whether or not to actually hold a hearing now, whether or not it needs to be held immediately. And the problem is, if you hold him in direct criminal contempt, as you're saying that you did, you are a witness to that proceeding. And so it has to be referred to another judge. Doesn't require recusal. You actually have to sua sponte send it to another judge because you are a witness to the proceeding.
Show me the case law that says that, Ms.
Yes,
Merchant.
it is Henry McClarty. It's 152 Georgia App 399. And it says that is one of the cases. Also, two other cases, Henry Adams, 215 Georgia App 372.
Well, 1 second. Give me the name of the first case again. Henry what?
Do you want just the number, Judge?
Yeah, I would. Thank you.
215
215
Georgia App
Georgia App.
372.
Okay.
Also 215 Georgia App 349.
Okay.
That's Adams and Hasty.
All right. Let me take a look at those. You have anything a little more current than 1994?
Hasty is 94. Unfortunately, contempt of attorneys is not a common proceeding, so most of the cases are a little bit older. But I do have other. And Judge, I'm not the only one here. There's quite a few other lawyers that want to be present in the court. There's about 20, 25.
The challenge is I've had space allocations, as I told you. So you can, like I said, since you are representing him, that's fine. He told us, Mr. Steele told us that. Anybody else, because I have security concerns as well, and we have to vet people to come in, then they can go to 8H and they can certainly watch the proceedings from there.
Okay. And Judge, for security purposes, they're all attorneys. They're all members of the bar. I can give you all their names.
They still would have to be searched and still would have to be subject to the court's protocols.
And also, there's room in the jury box, and then there's room in the courtroom. So we would ask that they be allowed to.
I don't want them in my jury box. Okay? No.
I understand. May one additional attorney come in, then Alex Susor. And we're here on behalf of Gactel for our strike force. He is the chair of the strike force. I'm the president of the Georgia Association of Criminal Defense Lawyers and also a member of the strike force. So can he come in as another attorney co-counsel?
Yeah, I certainly may, sure.
Great. Alex Susor. Alex Susor. Thank you, Judge.
Henry Adams, it has two issues. One is the motion for disqualification. Okay. And that's, and I think the judge went ahead and did some other things that caused there to be that issue presented. So I don't think Adam, I'm gonna take a look at the other case. That was Henry Adams. That was 215 Georgia 372. I'm gonna
Yes.
look at the other case just a second.
And there's several others when you're ready. Yes, it may be one I have too.
Hasty's conduct didn't rise to a level in this system warrant summary contempt by the court. That's the difference with Hasty than in this particular case. So,
and
I distinguish your two cases that you've given me thus far.
Oh, those were only the initial two. I had a couple others.
Okay, go ahead.
As well. Yes. So Ramirez versus State. It's $279, Georgia 13, 2005. It also.
You said 279 Georgia what? I'm sorry.
Georgia 13.
Georgia 13.
Mm-hmm. It's a 2005 case,
right.
And it defines direct contempt and explains that it must actually interfere with the proceedings to be direct. There's also a couple other cases on that.
See, but you all are covering under, let me see.
I'm sorry, Judge?
Hold on. Just a second. Pardon me. The contempt is directed. The trial court has the power after confording the contemptor to opportunity to speak in his or own behalf, announce punishment summarily and without further notice or hearing. I already did that, Mr. Steele. He's already told me, I already gave him the opportunity to do that. So we had that conversation this morning already. So.
And Judge, so there's a couple different issues. First, the question is whether or not you need to have that hearing now. I know you're saying that you had the hearing earlier, but regardless, he was entitled to have an attorney at that point, and he didn't have one. So the question is initially whether or not you even need to hear this now. And some of the cases I've cited, along with some others, say that a summary proceeding is not necessary in a case like this. And the best evidence of that is the trial has continued. It has not stopped this trial. So for you to hold a summary hearing of direct contempt, the court has to be able to state how this interferes with your ability to administer justice in this case.
Oh, I can tell you because it is a violation of the sacrosanct nature of the court's ability to hold ex parte conversations without those being broadcast to other people, and as to how that information was disclosed. That's a real problem. That's why it's of such an issue for the court at this point in time.
Judge, and Mr. Steele has a right to make a motion like this. If there were
he does. He does.
Does.
I'm not saying anything, but you know, but he's kind of put himself in a particular position he's in.
No, Judge, I don't agree. I believe that
I'm going to disagree with you, okay?
I believe that the court has put him in that position.
No.
He cannot be held in the law states, McClarity, which I cited to you earlier.
And it's true that direct summary contempt, which arises in the presence of the court, intends to scandalize it and or hinder or obstruct the orderly process of the administration of justice. The preservation of order and decorum of the court is exempt from due process requirements of notice and hearing. That's even Moody, goes back to 1974. So I believe that Mr. Steele, he can file whatever motions, but his particular actions in this case, I just want to know who told him this. That's all. I'm not asking him to release or otherwise tell any conversations, but I just want him to tell me that.
And Judge, so that's what you want, but that does not conflate to a contempt. Your desire for him to answer your question does not mean that you have the power to hold him in contempt.
So you can come into court, Mr. Merton, and not answer a question of the court and not be held in contempt?
If it's a question that the court is not permitted to ask, yes.
Okay, well, this is a question the court's permitted to ask.
And it's our position, if we had a hearing, we could explain to the court why he is not required. First of all, the court accused him of eavesdropping. That is a crime. He has a Fifth Amendment privilege against answering those questions. Rule 1.6 protects all confidential information that is gained not from your client, but in representation of your client. He has the ability to protect that information. But we don't even need to get there because he can't be held in contempt, and you can't threaten him with contempt for presenting a motion in good faith. He presented a motion in good faith that he believed there were ex parte communications. You are a witness to that because it's my understanding that you were part of those ex parte communications. They can't be ex parte if you aren't part of them, by nature.
Okay, well,
you have to be involved. Therefore, you have to be a witness. So you are a witness. You cannot also
But you got the information. But here's the thing. You got the information allegedly from an improper methodology. I'm not saying that he eavesdropped. Okay, I said that one of the things is it's either one of two ways. He either eavesdropped, which I don't believe he did at all. I don't believe that for a minute. But I do believe that somebody did tell him what was the sum and substance of the court's conversations, and that would not be permissible.
Judge, let's just back up for a second. He makes a motion because he has reason to believe that there were ex parte communications made. The court has a duty, if there are ex parte communications made, to alert counsel. He shouldn't have had to learn it from wherever he learned it.
I think that he caused that particular circumstance. I think that he had a conversation with somebody and he got some information that he shouldn't have had to begin with. So, Ms. Merchant, I'm of the opinion I'm going to stand on my ruling at this point in time. I'm going to hold him in contempt. So at this point in time, is there anything else you want to tell me?
Yes, Judge. There's quite a few other things. So first of all, we would ask for you to be recused from this case because you are a witness necessarily. It cannot be an ex parte proceeding without you being a witness to this. So you are a witness to this proceeding. Therefore, yes, to the contempt. To the contempt. You are a witness to the contempt. So you have now, and if it's criminal, which is what you're saying it is, Mr. Steele is entitled to all the same due process rights that Mr. Williams and every other defendant in this courtroom is entitled to. He's entitled to those. One of those is to have a fair and neutral judge decide his case. One of those is to have a judge who is not also a witness in the proceeding deciding whether or not he's in contempt. This needs to be heard by a different judge. And he has the right to subpoena witnesses. He has the right to an attorney. He has the right to due process, notice, a show cause hearing, notice of the alleged violation, whatever rule it is that that the court believes, and a hearing where he can call you as a witness. You can testify. You are necessarily a witness. You can't, for it to be ex parte, you have to be a witness. It can't be both ways.
I'll let an appellate court decide that. So, anything else?
No, we'll file a notice of appeal.
Okay.
And we need
Well,
to have the order reduced in writing as well. Judge.
I'm going to do that right now. I will say for the record at this point in time that Mr. Steele has in fact, or has filed, and I will note this as part for the record in this case. He's filed a motion to set aside the contempt. He's filed a motion for a supersedious bond, and he's filed a notice of appeal, all of which I will include as the next court's exhibit in order. But I'm reducing the contempt to writing. And I mentioned earlier, he can purge himself of the contempt just by telling me who it was, and he can do that this evening. He can do it right now. He can do it at any point in time. If not, I'll revisit the circumstance on Friday.
And Judge, we would ask that you grant a bond. At this point, grant him a bond on that issue.
You don't get a supersedious bond on a criminal contempt, though.
You can grant him a bond.
No, you don't get one on that one.
The civil is the one that you can hold him until he complies with the order.
And I'm sorry, I think in
Just the case law on that is in Ray Hughes.
Hold on.
Right.
The superseded bond requirement does not apply in the contempt in the presence of the court during the progress of a proceeding, OCGA 5-6-13 Bravo. So you don't get a supersedious on that, on a criminal contempt, respectfully.
So Judge, just to clarify, it's your ruling that this is a criminal contempt that Mr. Steele has committed, not a civil indirect contempt.
That's correct.
The judge, and that's the reason I'm asking is because the In Ray Hughes case, which is a 2009 Court of Appeals case, 268, Georgia Appeals 66, lays out the distinction, as does the Ramirez case.
There's a case that, in fact, I'll do you one better, sir. In fact, there is a recent pronouncement out of our appellate courts.
Well, Judge, I think I'm addressing a slightly different point of law.
It is. Hold on. One second. Give you two cases. One is it's Untema. It's UNTEMA versus Smith, and that's 371 Georgia Appeals 19. Which was decided March the 12th of this year. It covers the differences between the types of contempt. And then there's another case that I'd invite your attention to, and that is Henry Syverson. It's SYVERTSON, and that is 368 Georgia Appeals, Georgia App, I should say, 865. And that was decided July 31st of last year.
And Judge, I'd just like to point two things out. The statute that you were citing about the supersedious, it only says it's not mandatory. You still have discretion to grant him a supersedious bond. The other...
I'm not going to grant him a supersedious bond.
And so you definitely have the discretion to grant him a supersedious bond. The other issue is if it is a criminal contempt and you are finding him guilty of criminal contempt, then we have to have a sentence imposed. Now, civil is where you get to hold him until he complies.
No,
criminal is where you get to impose a sentence, maximum 20 days and $1,000 fine. So if you're going to incarcerate him under a criminal contempt, he's got to be sentenced.
Well, his contempt is, as long as he, when he tells me what the basis of the conversation was, I didn't ask what, but he tells me that, then I can certainly, he purges himself of the contempt.
Then that's civil, Judge.
That's civil contempt.
That's civil.
Judge, and that's respectfully, I would point you to In re Hughes, which stands for the same point of law. Civil contempts impose punishment as a means of coercing future compliance with the prior order of the court. Here, the prior order of the court presumably is that you have directed Mr. Steele to answer the question, to disclose the information as to who is his source for knowledge of this ex parte meeting that occurred earlier today. Criminal contempt imposes unconditional punishment to punish the act which has occurred in the past and cannot be purged. It is not capable of being purged, in which case what Ms. Merchant said applies, which is that there is a 20-day maximum sentence and $1,000 fine. It is, for all intents and purposes, a misdemeanor offense, Judge, which is why the enhanced due process protections apply to that. Now, Mr. Steele has indicated to us he does not believe that he can answer the question without violating his duty of loyalty and duty of confidentiality to his client. So he is being placed in a position where he's either going to jail or he's going to commit an offense that will put his license to practice law at risk. And that is an untenable position to be in. And Mr. Steele is a zealous advocate for his client, and he is simply trying to protect that duty of loyalty and duty of confidentiality, because if he answers your question, it is very reasonable to assume and likely that he will be facing a bar complaint that could result in a suspension or in the loss of his license. And so he's in a very, very difficult position where if we were able to have a full contested hearing with the benefit of witnesses and an impartial judge where you're a witness, then everybody could present their side of the story. And
I'm not doing that. The reason being is because that takes away the whole point of criminal contempt. And that is, you do something, the court tells you to do something, order of the court, and you don't follow it. I didn't ask him to do anything illegal, immoral, unethical. I just asked him to tell me. I know what the privilege is. The privilege is the conversation. I didn't ask him about that. I wanted to ask him about who, the person, okay, I'm sorry.
Sorry, Mr. Steele has indicated to us that he does not believe he can answer that question without also violating the privilege.
Okay.
And Judge, that's why we're trying to figure out if it's criminal versus civil. So the issue is you're picking and choosing. You're saying, well, you get the bad side of criminal and no bond, but I really am actually trying to punish you civilly, which is when you hold someone until they comply.
Okay, let me think about it just a second, okay? I'm gonna take 5 minutes out. I'm gonna think about it.
Thank you.
Okay, all right. So
he doesn't know what he's doing, and he's gonna come back and then try to make it right, as if he know what he's talking about. He changed his mind. He thought about it. No, the law changed his mind. He doesn't even know what he's doing. Okay, I just wanted y'all to see his arrogance there. Now we want to go to
the Glanville Act.
Oh, that's the actual document itself that
I'm not a lawyer.
I like her. She's 2 minutes. I can play this right quick. Hold on. Boy, I don't know what's going on with this little Ethernet thing. I thought it was going to be the answer to my problems, but it is not. So I got to find out what's going on. I love her too. I'm not a lawyer, but she...
But there are already a couple of updates in the YSL RICO trial, so let's talk about them. First, you see this. That's the name of the new judge assigned to oversee the motions to recuse Judge Glanville in this case. So new judge's name is Judge Rachel Krause, and you see here she is a judge with the Superior Court of Fulton County. So she's been assigned to this case and she's already issued her first order. This is the order, and you see here she lists out the 3 motions to recuse Judge Glanville. The first was filed on behalf of Diamante Kendrick, the second was filed on behalf of Jeffrey Williams, and then the third was filed on behalf of Kayla Bumbus. And I just want to read this next sentence, which says that time is of the essence, given that a jury trial is currently paused pending resolution of these recusal motions. Therefore, the court hereby orders the state to file a written response to the pending recusal motions on or before 5 p.m. on Monday, July 8th. So the state has until Monday, July 8th, to respond to these 3 motions, and we can already bet what they're going to say. But here's the thing. Right before new judge Rachel Krause submitted her order, Doug Weinstein, who again represents Diamante Kendrick, filed another motion. And his motion is a motion to disqualify Fulton County Superior Court judges from ruling on recusal of Chief Judge Glanville. Y'all following what's happening? Judge Glanville is the chief judge in Fulton County Superior Court. So Doug Weinstein's motion is requesting that all of the judges listed on this Fulton County Superior Court page be recused or disqualified from overseeing the motions to recuse Judge Glanville, including Judge Rachel Krause, because they work together. And Weinstein cites an opinion from the Judicial Qualification Commission, which says, quote, "It is inappropriate for any trial court judge to preside in any action wherein one of the parties holds a judicial office on the same or any other court which sits in the same circuit." Just follow me, because these next couple sentences are going to sum it up really nicely. And it says, "To avoid even the appearance of impropriety, Judge Krause and any other judge within Fulton County should recuse from hearing Kendrick's recusal motion." And then further down, it says, "Mr. Kendrick respectfully requests that Judge Krause and any other judge within Fulton County recuse themselves and facilitate such actions as necessary to have the motion heard by a judge outside of Fulton County Superior Court." Make sense? So that's where we are. The response from the state is due by Monday, but we may have a new judge by then, or maybe shortly after. We will see. Before I go, my interview with Doug Weinstein is going to be dropping tomorrow on my YouTube page, so go subscribe, watch, listen. I promise it's a good time.
And I did put her link in the description. She's really good. She does good commentary. She just tells the points. She doesn't give her personal opinion. Very good. Okay, now here's our young man and his father, who's going to break down this. And if I may lose a few of you, but hopefully this computer will act better. I don't know, but we'll see.
Then we'll be in recess.
Other judge take a look and make a decision as to whether or not he should be recused in this case. And he also makes a very important statement that they are pausing proceedings of this trial temporarily, which, while is probably the legal right thing to do, kicks everybody in the gut a little bit, because delays are not what anybody wants to hear at this point in the trial. So let me pull that clip up. All right, here we go.
And then then transitioning to the last matter the court wanted to put on record. Upon further review, this court will in fact enter an order sending Mr. Adams and Steele's, Mr. Weinstein, and Mr. Banks' motion to recuse to another judge. pursuant to Uniform Superior Court Rules 25.1 through 25.7 in the method and manner prescribed by our local rules. So,
Mr. Weinstein asked him to do that and told him to halt the procedures according to 25.3. But he was so arrogant, he wasn't doing none of that. They can take all that up on appeal. But when the Supreme Court denied Mr. Weinstein's motion and sent it back to him to do the right thing, yeah. Listen how he sounds. He doesn't sound as arrogant as he sounded when he was talking to them in the courtroom, telling them what he wasn't going to do.
So this written order is entered. I will enter the order transferring it. And until such time as those two things are decided, then we'll be in recess until that time. And we will just inform our jurors that they're until they're not supposed to come back on Monday, until Monday anyway. So I will have Deputy Ingram and Ms. Umana indicate to them that they are still on recess and we're continuing to work. So that's all I have for you at this point.
So he kind of indicates there that maybe this will happen sooner rather than later, and maybe even it'll be taken care of before Monday when the jurors are supposed to come back after the 4th of July holiday. What are your thoughts and comments about the Supreme Court's ruling on the writ? Because they did not recuse him. It wasn't technically a big win for the defense, but they did enough, obviously, to push Judge Glanville to make this decision to let another Superior Court judge. Now, this is somebody that works with Judge Glanville and will know Judge Glanville, so that will help him a bit, I'm sure. But they pushed him enough to make this decision that somebody else is going to make a call in this case.
Well, first off, the writ of mandamus that went to the Supreme Court threw it out on technical grounds, saying that it should have been filed in the Superior Court first. They didn't follow the proper procedure, all that stuff. And they didn't have to say this, but they did. That if they do file it before Judge Granville, he has to assign another judge to hear the writ of mandamus, because the respondent, in other words, the defendant on the writ of mandamus, they're called respondents on writs. The respondent would have been Judge Granville. So, since he was a party, another judge has to hear it. That was a signal to Judge Granville that somebody else needs to hear this, because if he files a writ of mandamus, he's going to have to send it to another judge anyway. So he got a clear message from the Supreme Court.
Right, and Judge Glanville is going to do that at this point, and he is going to let another judge take care of it. He's not going to fight it anymore. He's not going to. And another reason is the Supreme Court's basically saying it should start here. This is where the writ should be filed before it gets to us. That's kind of the technical part you're talking about, which is fine. It's not a loss for the defense. Technically, it ends up being a win, because they do want, it's not a home run, right, where he just gets recused and they get to do this the way that they want to. But at the very least, another judge is going to look at it and hopefully bring an unbiased view and opinion on to what should happen next. And all of this really boils down to an ex parte, quote unquote, secret meeting between Judge Glanville, prosecutors, investigators, Kenneth Copeland, who was a sworn witness at the time, and his stand-in attorney. The big fight.
Go ahead. No, go ahead.
The big fight has been around this transcript. What was said, what happened, and Judge Glanville said he was not going to release the transcript. Then he was going to release it, but he was going to redact the privileged information. Nobody could really figure out what would be possibly privileged in this ex parte hearing. So now there's been another hearing where Judge Glanville has made a decision on what he's going to do with that transcript. Is he going to release all or part of it? What is privileged, if anything? And what does he want to take judicial notice of? Because all this is really important, because we were also supposed to have a show cause hearing for anybody to come out and say, whoever was in that meeting, come and tell me in the court that you didn't tell everybody what was going on in there, because that would be a really bad thing. And I may hold you in contempt. I may sanction you. I may throw you in jail. Well, all that becomes moot if he releases the entire transcript, right? So that's why this hearing is kind of important here that we're going to listen to next.
Well, and what he said in other portions of that particular hearing was the name is going to be put in the normal course of events. It's going to go on the wheel, which means a random selection of a judge that's going to hear it. However, there is an argument that the JQC, the Judicial Qualifications Commission rules in Georgia require a judge from another circuit to hear it, since he's the chief judge of that circuit. So there's going to be an argument about even which judge is actually going to hear this.
I mean, to me, that just makes too much sense. Like,
Yeah.
obviously, it should not be a judge in his jurisdiction where he's the chief judge. That seems obvious to me, but common sense and the obvious answer doesn't always end up being right in law. But we'll see. At the very least, some other judge other than Glanville is going to take a look at this. And I don't think they want to be stained and throw themselves under the bus for Glanville if they really think he did something wrong. So we're going to hope the judiciary is going to make the right decision, whoever ends up getting called up. But I think I agree with that, and I love that idea that somebody outside of his jurisdiction will make the call. Okay, so now we're going to transition into the hearing where they discuss the transcript.
As you all are made aware, last week the court was going to do an in-camera review of the ex parte proceedings on June the 10th of 2024. In considering whether or not to have an in-camera discussion or review the records, this court has decided to release the entirety of the transcript.
So right off the bat, first thing he says is, we are going to release the entirety of this transcript. So what does that tell you about privilege and what was potentially going to be redacted or blocked from the public or from the defense attorneys?
There is nothing privileged. Nothing needs to be blocked. Everything that happened at that hearing, the defense lawyers can know, and they could have heard, and they could have been there. And these, I guess it's been 2 weeks that we've been dealing with this. I think it was the 12th that he had that first hearing. In the last 2 weeks have been a total waste of time. And he could have released the transcript, told everybody he was going to release it on the first day, and it certainly would have shortened the process.
To me, all it makes me think is he didn't fully remember what happened in the hearing, so he wanted to take a look at it himself and see how bad it was potentially, and if there was any way he could have blocked anything. But overall, I mean, we're going to dig into the details, and there are some pretty shocking, horrifying, terrible things that happened in that hearing with respect to a criminal defendant's rights. But most of the gist was what people were reporting and talking about happened in this hearing. But we're going to get into the details once we get to the full transcript. But let's hear him take judicial notice, make a couple other decisions that are very interesting as far as what's going to happen now.
Of those proceedings. As courts won. And I'm going to take judicial notice of the following timeline. On Friday, June the 7th, 2024, Mr. Kenneth Copeland was granted immunity from prosecution pursuant to 24-5-507A, and that will be marked as Courts 2. So the transfer will be Court 1. His immunity agreement, Mr. Copeland's, will be Court 2. Mr. Copeland, who was represented by Mr. Jonathan Melnick and advised of his rights and obligations, during the proceedings on Friday, June the 7th, which will be marked as Courts 3, the transcript of those proceedings, Mr. Copeland invoked his Fifth Amendment privilege and was held in contempt, and that will be Courts 4, Mr. Copeland's order of contempt. Mr. Melnick.
The timeline is important because he was granted immunity before he pled the Fifth, which is why he was thrown in jail. If that would have been backwards, it may have been different. We'll get into that a little bit more as we read the hearing transcript.
Informed the court that he was not going to be in attendance of any further proceedings, as he would be on leave effective 10 June of 2024. The court informed Mr. Melnick that his leave, or had discussions with him that his leave was not proper and that he needed to be in attendance on Monday, June the 10th of 2024 with Mr. Copeland. Mr. Melnick relayed that attorney Caleb Bumpus would be representing Mr. Copeland. On Monday, June the 10th, before court, Mr. Edward Chamberlain, the court's litigation manager, informed the court that the state wished to have an ex parte meeting with court. No subject matter of the ex parte meeting was told. The entirety of the ex parte hearing held on the 10th of June.
In my opinion, the judge is lying. They told him that in court on Friday. They had a meeting Friday, and when they came Monday out, they already knew to go to his chambers because they never went to the courtroom. So the judge is lying yet again.
June of 2024 was taken down by Ms. Christina Weaver, the court's official court reporter. This ex parte hearing was held in chambers starting at 9:10 a.m. Present along with the court were Ms. Caleb Bumpus, attorney or ADA Ms. Adrian Love. Also present were the DA's investigators, Mr. Long and Mr. Hamilton. The ex parte hearing stood in recess from 9:34 to 10:03 a.m. to await Mr. Copeland's arrival.
All of this, by the way, is noted in the transcript that we'll look at too. When they took a break, when the court was in the room. when the Kenneth Copeland was in the room, because he was not in the room for the entirety of the hearing in the transcript, which we'll see.
The ex parte hearing resumed with Mr. Copeland present at 10:03 a.m. Also present were Attorney Bumpus, Ms. Hilton, the DA's investigators Long and Hamilton, the court and security personnel, deputies Houston, McPherson, Brown, Sergeant Brown, and Sergeant Hall.
It's a bunch of cops. It's like 4 to 6 cops standing in there with the judge and a couple prosecutors with Kenneth Copeland. How do you think he felt? Do you think there was any coercion? Do you think there was any pressure? Or did you think he just felt free, like he was represented by his lawyer and he could say whatever he wanted to?
Right? That was the whole idea. I mean, it was designed. These things are designed this way. I mean, that's the whole point. And there were people in there that didn't have to be in there, but
Like
they were all in there.
Be there, but the defense didn't have to. It's crazy.
No, I'm talking about there are investigators. They just packed that room.
Right.
The ex parte hearing stood in recess to allow Mr. Copeland to have a private conversation with Attorney Bumpus from 10:17 a.m. to 11:28 a.m. The ex parte hearing resumed at 11:28 a.m. The ex parte hearing concluded at 11:31 a.m. The court arrived in courtroom 1C at 11:49. The transcript of those proceedings, starting as of 11:49, or when the court presumed that held the proceedings on 10 June in courtroom 1C 2024, that will be marked as courts 5. The proceeding in 1C commenced on the record at 11:52 a.m. A lunch recess was had at 12:51 p.m. The parties returned from lunch, and Mr. Steele informed the court that he had a motion, and that was at 1:46 p.m. In asking Mr. Steele later that afternoon was held in contempt. However, he was allowed to continue representation of Mr. Williams.
Oh yeah, we don't want to forget that.
The court, in asking Mr. Steele questions of how he received the information that he proffered in open court, was only concerned about the integrity and security of the conversations that were had in chambers, not whether those conversations were the subject of proper ex parte conversations or the sum and substance of what was told him at that time. Jurors Jurors entered the courtroom to resume Mr. Copeland's testimony at 3:39 p.m. The jurors were excused and exited the courtroom at 5:56 p.m. Mr. Copeland was excused and exited the courtroom at 5:58 p.m. The court asked Mr. Steele again whether he received ex parte information, and that would be at 5:59 p.m. Mr. Steele's counsel, Ms. Ashley Merchant, and Mr. Alex Susor entered the courtroom. Mr. Steele was held in criminal contempt. That order of that contempt will be marked as court 6, and the proceedings concluded at 7:41 p.m. The court further takes judicial notice of the following statements proffered by Attorney Brian Steele, in open court upon information and belief stated to the court, which are still on.
This is all for his order, because he's making an order, releasing the transcript, wants to give the timeline, and wants to say now what Mr. Steele said and take judicial notice of them.
Known. There are 6 assertions that Mr. Steele proffered in front of the court. Those are contained within the transcript of courts 5. The proceedings that are held on the 10th of June of 2024 in courtroom 1C, which of course already said will be part of this order. The first assertion and the transcript bears out exactly what Mr. Steele said, so the court is paraphrasing the 6 assertions that Mr. Steele made. They're more aptly and more eloquently put in the record. The first one involves his concern that supposedly in chambers, this honorable court reporter, court at times, district attorney or district attorneys before the DA's office, as well as investigators, sheriff, and deputies, Mr. Copeland and his counsel met together. None of the defense team, to his knowledge, were present. Second assertion he makes is that Mr. Copeland intended to plead the Fifth Amendment.
And these are important for us to listen to these now before we read what actually happened in the transcript in the hearing, because these were Steele's big gripes and big problems. And the court is putting them on the record before anybody gets to read the transcript. So it's important to know what the beef was that the defendant had, because if none of those came true in the hearing, then it would be a moot point. But if they were legit, then there might be a problem, right?
Oh, yeah. That's the whole issue. But again, he has to presume that they're true when he's reading these.
Right.
Third assertion is that Mr. Copeland, as a party, was sworn, and Mr. Steele asserted that this particular conversation was, in fact, a critical stage, and that the defendants had the right to be present. The fifth group of assertions involved Mr. Copeland not going to testify. The fifth group of assertions involved what Ms. Attorney Hilton claimed or said to the witness, to include the court, involving allegations of coercion and witness intimidation, and that his counsel had the right to be present. And the sixth assertion that was made in open court was that Mr. Copeland admitted to killing Donovan Thomas. At some point after Mr. Steele was held in contempt by this court in the afternoon of June the 10th, it was brought to the court's attention, not at the court's request, by security personnel, that video footage of what occurred outside courtroom 1C shows the interactions between Ms. Bumpus, Mr. Steele, Mr. Adams, and Mr. Sharp. The court in no way sought to investigate any facts of this involving this footage.
So he's basically saying he thinks that's when Bumpus told him what happened in the ex parte hearing, right?
Well, that's what he's saying, but later on we're going to talk about it, but I don't think that's what happened.
And only considered it for the security and timeline of events that occurred on June the 10th of 2024. Also, in no way did the court consider any of this footage in holding Mr. Steele in contempt. And as I said, mentioned it only for the...
Then why mention it?
The purposes of considering the security and breach of information that occurred within the court's chambers, not for whether or not that was truthful or not. Mr. Steele makes further made three assertions on the 10th of June of 2024. One, he asserted that this was on behalf of Mr. Williams and similar situated individuals, that this was the court held an improper ex parte meeting. Secondly, that Mr. Copeland was a sworn witness, and this was a critical stage. And Mr. Copeland was a sworn witness. And third, that he argued that this was a critical stage, and that he and the others needed to be present at that point in time to pursue the Sixth Amendment rights of the defendants in this case. As to Mr. Steele's first assertion of whether or not the court held an improper ex parte meeting or hearing, the court is guided by Judicial Code of Conduct 2.9, which I'll take judicial notice of, which in pertinent part, where circumstances require ex parte communications are authorized for scheduling, administrative purposes, or emergencies that do not deal with the substantive matters or issues, provided that the judge reasonably believes that no party will gain any procedural, substantive, or tactical advantage as a result of the ex parte communication. And the judge makes provisions promptly to notify all parties of the substance of the ex parte communication and gives parties an opportunity to respond. And in this particular circumstance, the transcript of these proceedings was just prepared and is final by my official court reporter, Ms. Weaver, and all counsel will be, as I said, given an opportunity to, as soon as the court finishes entering this order, it will be e-filed, so everyone will have a chance to take a look at it and use it as they see fit. In this particular, and then the last part of 2.9 before the court goes on, if involves in pertinent part, if a judge inadvertently receives unauthorized ex parte communication bearing upon the substance of the matter, the judge shall make provision promptly to notify all parties of the substance of the communication, provide the parties with a reasonable opportunity to respond. And as I mentioned earlier.
So just that right there says if the judge inadvertently becomes aware of ex parte communication, he should let everybody know.
Right. That's the notice requirement. That's the way you can cure a lot of problems. By telling everybody, what happened.
Which we've seen in lots of trials. It's like, hey, I just want to put everybody on notice. This happened. You just cure it. And it shows you're not doing anything nefarious. You're not trying to hide anything. You're not doing anything slimy. But he didn't do that here.
Well, like
I'm gonna go down a little bit since it's a little ways, but they say some good stuff in here. Well, let's hear him read it, because it's going to be something that he reads that the daddy is going to bring it back to his attention.
And she's, I believe, the chief assistant. I believe Ms. Love is the chief assistant.
To handle this case, which is a very big case.
Right.
But then,
it's terrible.
So that. All right. Here we go. Transcript of the ex parte hearing, Judge Glanville, June 10th, 2024. So here's present in chambers at this point at 9:10. Glanville, District Attorney Love, Attorney Kayla Bumpus, who is Kenneth Copeland's attorney, reporter. What is that?
Guy cleaning the outside of the house.
Okay, I'll mute your mic and I'll unmute it when it's.
Yeah, go ahead and mute it.
Okay. Okay. So, present is Glanville, District Attorney, Attorney for Copeland, court reporter, and 2 investigators at this point. Judge says he's ready. Ms. Love, the ADA starts. That talks about twofold concern. One, we wanted to have the opportunity to impress upon Mr. Copeland with representation present that he faces, and we wanted to give him an opportunity to ask whatever questions he wanted to ask before he was we had to pull him into the courtroom when the jury comes out. The second concern that I have is I wanted to bring to the court's attention, in line with the concern that I expressed on Friday. I don't know what advice counsel may be offering or may be offering. That is their right and their business. So why is that a second concern? That she's worried about what advice a criminal defense attorney is given, a witness potentially looking at criminal implication.
Okay. I'm sorry, you may still be able to hear some of it outside there, but
you can just talk normal.
Okay. Go up to the top, and the interesting thing is you do not see the judge saying anything before this starts. How is that possible that the judge didn't say anything before this hearing starts? And it starts out, the first person speaking is Miss Love. That's number one. Number two, the judge makes no determination as to why this is an emergency motion. Why doesn't the defense have to be here? Ms. Love, before you talk, explain the emergency nature and why the defense cannot be privy to this information. None of that. So we start out with Love, so you know that there was stuff talked about and said before this transcript started. I mean, it defies logic to think that there wasn't. And then you look at these 2 particular issues. Where is the safety of the witness? They don't really worry about the safety of the witness. They're more worried about the fact that they're not getting their way with the witness because the witness has a lawyer that's not letting them get their way. And so they don't like that. So they want the judge to take care of that. And they want the judge to intimidate the witness so he testifies. Basically, that's what they're saying.
So it also comes down to, he talks about, or she says, as it relates to testifying, I don't believe criminal exposure is a concern. It's like, well, you're the prosecutor. So it's not up to you to advise a potential criminal defendant on what the criminal exposure is. So she is, to me, this prosecutor, as we read this ex parte hearing, does not live in reality. Like, I would never act how she acts and acts like she has all the power to do whatever she wants. And if she says it, everybody's got to listen to it. The judge, the prosecutors, the criminal defendants, the witnesses, and she just, whatever call she makes is all that matters, which is just not true. And it's not correct. And she misunderstands so many different aspects about how the attorney-client relationship works when you have potential criminal liability.
Well, I've got to, I've been a state prosecutor and I've been a federal prosecutor. She's embarrassing. And I was the chief of the criminal division as well as the felony division of the state attorney. If I had an assistant that said these things and acted like this, I send them back to school. She missed the boat somewhere in her training. And she's, I believe, the chief assistant. I believe Ms. Love is the chief assistant.
to handle this case, which is a very big case.
Right.
But then
it's terrible.
So then she says, Mr. Melnick relayed to Miss Hilton, which is the other prosecutor, on Friday that he never heard of statute 245507. And on Friday sent an email. I don't know if he intentionally copied Mr. Steele and Mr. Shart. I don't know if he unintentionally put my name on it, but he sent an email to Mr. Steele, Mr. Shart, with me and Simone, where he said, this is the communication I received from Miss Love regarding Mr. Copeland. First off, I don't think that was a mistake. I think he wanted the other criminal defense attorneys to know what's going on and what the prosecutor's telling him. There's nothing wrong with that.
Well, first off, it's one of the things the problems that prosecutors have is this is a full disclosure. He told everybody what was going on. It was no secret. And the other thing is, think about this. They do an ex parte hearing, and what do? They bash the defense lawyer who's not there and telling the judge, look, this guy is stupid. He doesn't know the statute and he can't defend himself. He's not there. So they just rip him.
My response was, whose interests are you protecting? Yours or Mr. Steele's? Which client are you protecting? Whose client? Yours or Mr. Steele's and Mr. Shart's? He wrote back saying, you are going to get him killed. You are making him a target. F you, is what he wrote in the email. So again, do we really think she cares about Mr. Copeland's best interest? She cares about her case, what she wants, the testimony she needs, and she's trying to make it seem like he's doing something shady when in reality, witnesses for the prosecution cooperate with defendants all the time. We talk to prosecution witnesses or defense witnesses all the time who tell us what they're going to testify to, whose lawyers work with them. There's nothing wrong with that. He's not beholden to the prosecutor's office. So for her to act like there's some wrongdoing here is just unbelievable. And then number two, he's basically saying what you're doing is putting Mr. Copeland in danger and you don't care.
But again, he's not there and he can't defend himself. This is an easy hit for the prosecutor.
Additionally, there have been stories that other people connected to Mr. Copeland have not done well since all of this. This portion about Mr. Melnick is also interesting as to whether or not he represented Mr. Copeland at the time. And it comes down to, and what we're going to find out is, he's basically saying, if the prosecutors are having these off-the-record conversations that aren't recorded with Mr. Copeland, it's hard for Mr. Melnick to represent him if he's going to go testify. So if he's going to testify, he's not going to represent him. And the prosecutors are trying to make it seem like Melnick is doing something wrong in that situation.
This is another huge ethical problem for these prosecutors. Throughout this transcript, they admit that they had private conversations with Copeland without his lawyer there. They know he's represented. They know he has a lawyer. Regardless of this garbage about Copeland saying, I wasn't represented, I am represented, the facts are there is a notice of appearance in a criminal case, in a file, where Melnick is his lawyer. Those lawyers are duty-bound to recognize and respect the fact that he has a lawyer. Until the judge releases him from his duties as a lawyer, Melnick is that man's lawyer. And these prosecutors are just outrageous in the way that they're trying to manipulate Copeland to get between him and his lawyer. That's outrageous. Hopefully somebody's filing a grievance against them.
And what else is problematic and annoying is we're going to see in this hearing, and we saw outside in court, how Glanville just wouldn't let the lawyers walk away from Copeland. They basically forced them to stay, which shows that Copeland randomly saying, I'm not represented, doesn't matter. And all lawyers know that unless a motion to withdraw is filed and then granted by the judge, because sometimes lawyers want to get off the case and the judge says, too bad, no, you can't. So it doesn't just go in and out like you're represented by counsel 1 minute and 1 minute you're not, which is what it seemed like through this. So then they kind of discuss, how long he could potentially be in custody, what Ms. Bumpus needs to explain to Mr. Copeland. Is it the end of this trial or the end of all the trials? Bumpus says she just wants to be able to give him, and the court said, I know. It's kind of a statute. It's kind of the statute says, that you purge, but I can't keep him there indefinitely because, again, they're discussing whether it's till the end of this trial or the 12 other defendants that haven't been tried yet. And then we get into, but what we overheard being said, and I believe this is the prosecutor again, overhearing conversations between Melnick and Kenneth Copeland attorney-client privilege private conversations that they are listening to, they are going to hammer you as if we're going to expose Kenneth Copeland to. Ms. Bumpus said, "You heard that?" And Ms. Love said, yeah, Mr. Melnick told Mr. Copeland we're going to hammer him.
Right. And then the court's comment right after that is interesting because the court is actually trying to explain that away.
Now, to be fair, as I think Ms. Bumpus as an advocate or anybody has got to tell him he's going to face some pretty significant cross-examination, which is not what they were saying. And Bumpus said, I think that's what he meant. The court said, I mean, he's got about 10. And Love said, so he meant the defense is going to hammer him? Ms. Bumpus said, no, just in general, it's not going to be a hey, da-da-da. He knew that. He's already been expressing that. Right. But here's the thing. He knows, like only Copeland knows what he knows and what he's going to say and what he's going to testify to. So maybe Melnick knows some of it too. Are we really supposed to believe that the prosecutor's not going to hammer him as well? If he lies or he says something they don't like or he pleads the fifth, he's going to get thrown in jail and he's going to get hammered on direct and he's going to get hammered on cross. None of these lawyers represent him. None of these lawyers like him. So it's a completely correct statement to say the lawyers are all going to hammer you throughout this process. And
Right.
that's something.
And the sad part about it is in court, she said they heard it from somewhere, but in this meeting, she said she heard it. So which one is it? It sounds like she lies as much as he does.
A lawyer is advising him of that the prosecutor's overhearing. And she has no fear. Once again, if I did hear this, I would be like, oh, crap. I just heard attorney-client privilege information. I need to let them know that I heard it. I'm not going to use it in any future arguments or against anybody. That's what you're supposed to do. Instead, she just openly in front of the judge is like, Judge, I heard him talking to his lawyer, and this is what he said. I have a problem with what his lawyer advised him of.
See, what's happening here, and your listeners should recognize the fact that all the impropriety that's occurring here is the prosecutor. Everything that they're doing unethical, repeatedly unethical things over and over again. The judge's sin is that he's letting it happen. That's the difference. The difference is the judge may not be saying anything that's really bad yet, but he's letting the prosecutor go crazy and act unethically. And he still has not recognized why this is an emergency and why this should be an ex parte hearing.
Yeah, and again, the judge should have just said to her, Ms. Love, that's a privileged conversation. I'm not going to consider what you're saying there. Like, that's what he should say. He should not consider that statement.
Right. Or ask her, why were you talking to Copeland without his lawyer present?
Right.
That's a question he could ask as well.
Then Bumpus says he doesn't know what was said outside of his presence. Again, this is Melnick. So he doesn't feel like he can adequately represent him or counsel him because he doesn't know what was told to the state when he wasn't there. That's totally fair, right? He doesn't know what his client told the state. He can't advise him, that's a lie, that's not a lie, that could open you up to criminal prosecution. That couldn't, because he doesn't know what's going to be inconsistent. He doesn't know what was happening in these conversations. And also, the state wasn't recording them. That could have been solved. They could have recorded them and then given them to Melnick so Melnick would know what was said, but they didn't do that. Then they start defining what a lie is. And by a lie, we don't mean like, oh, I think you're lying. I would love to be. Something obvious, because we can always impeach. But if he literally perjures himself, that's something different. We can't help that. We can't control that. Tell the truth. I don't care how bad it is. Just tell the truth. And they mean the truth, what they think the truth is. And even Copeland starts to pick up on that. Like, what if you think I'm lying? So they give some examples. Love says there's been an assertion that people are representing that their biggest concern is his best interest, and they're just not here. And Ms. Bumpus is saying she's not in position to do that. Bumpus says, I'm saying the agreement between Copeland and Melnick, who I'm standing in for, is that if he chooses to testify, I'm to get him to sign this paper that says he discharges Melnick, which again, prior to this point, no discharge papers for Melnick. That's their agreement. I can't do nothing about that. Love said, that sounds weird. It does not sound like something in Mr. Copeland's best interest. That sounds like protecting somebody else's best interest. If you talk, I ain't going to. I'm not going to represent you. I don't even know what to do with that. Bumpus said, well, he said he does not know what was said. I think it's totally fair for Melnick and Bumpus to be in this position, don't you?
Well, it is, but Melnick, and the judge will go through this, Melnick, that really is not a good thing for a defense lawyer to say, that they're forcing him to withdraw if he testifies.
But don't you think his reasoning is sound in that if he testifies, the issues that will come up while he testifies, Melnick will not be able to represent him on?
Oh, absolutely. And you might want to file a motion with the judge, asking the judge to let you off the case because of that. But that's what you should do, is file a motion with the court and have the court have a hearing on this information. But you're right. It's perjury, the prosecutor decides what perjury is. And, if they have statements that you don't know about, well, how can you defend your client?
And the issue was created by the state.
Yes.
Having these conversations without counsel present, from my opinion, those conversations should just be struck. They should not be able to impeach Mr. Copeland based on anything that happened in those conversations. There are ways to fix this where you could force Melnick to stay on. Meaning anything you don't know, Mr. Melnick, or you weren't there for, can't be used against Mr. Copeland. That's a fair remedy to me.
Except the judge cannot control what later on the state attorney may file a charge of perjury.
Correct.
The judge can't control that. He can control what happens in this trial, in this case, but later on, if there's a charge of perjury, the judge can't stop that.
Right, but what he can do is say you can't use that stuff, and if you are going to use that for a crime of perjury, then you're not actually giving him the proper immunity, so I'm not going to throw him in jail for contempt for not testifying. The judge can do that.
I don't know if he can. I'll be honest with you. I don't know if he can interfere with prosecutorial discretion.
But you think so? The judge has to throw him in jail if he won't testify?
I think if he keeps the fifth, yes, the judge has to throw him in jail.
Oh, I don't think that it's that black and white that he would be forced to do that.
I think so.
Okay. So next, Miss Love says, Copeland was like, hey, he's not my lawyer. I don't have a lawyer. We've already kind of heard some of that. So then we get to the fact that Miss Hilton had a list of questions for Mr. Copeland, which I thought was interesting. And again, something that if defense counsel was in the meeting for, they might want to know. Ms. Hilton already shared the list with Mr. Copeland, and they'll share it generally speaking. Can I read this email Melnick sent? Can I read you this email Melnick sent me? I don't know if it'll help you understand what he's saying. So that's
Can I just raise one thing about that?
Yeah.
You see that where the court says, I thought that Ms. Hilton had a list of questions for Mr. Copeland.
Yeah.
Maybe I missed it, but I went back in his transcript. I don't see where the judge was told that in the transcript. So there must have been a conversation outside of what's in this transcript where they told the judge they had this list of questions. So that's another clue that something else went on before this transcript started.
That again, I believe, is the ex parte meeting that took place on Friday when they got everything together and put all of this together for Monday morning. That's just my observation.
And I think they've had hearings and talked about Copeland a lot throughout the trial, like even outside of this with the defense lawyers there. But the defense lawyers will know because they've been there this whole trial. They're going to comb through this and pick through this. And if there's more indications of that, there's going to be more problems. Ms. Love said, so he can't force Mr. Copeland to discharge him just because Copeland decides to testify. The court said, I think you are in until it's done. I mean, and Bumpus says, who, me? The court basically says he's going to force Bumpus to stay on. And Ms. Love said she's in a tough position because she's not the one that interjected herself. Melnick is, and now she's standing in for Melnick. And they talk about the...
And just tell me, how did the man's attorney interject himself? It seems to me that Love is interjecting herself. She and Simone.
immunity agreement and how they're not going to use anything he says against him. They're not going to prosecute him for anything that he says. Of course, later they say, well, if he makes up certain lies, that could change, which we'll talk about. You're his lawyer.
Remember the 3 immunities we just went over? They gave him use immunity, which is the lowest one. Only your words that you use in that courtroom can't be used against you. Your words. Unless, of course, like they said, you're lying. Then they talk about impeachment, not as if it's really catching you in a lie. It's just that it's an inconsistent story. It's the things they were telling this young man, and he told them he didn't understand what was going on. And I guess since he lied so much, they didn't even want to believe that. But if they don't understand the law and know what they're talking about, how in the world he gonna know? But let's keep listening.
Lawyer, you're a stand-in lawyer at this point. Judge is going to force Bumpus to stay on. Love said we can't use his testimony to go find evidence to prosecute him for the stuff he talks about. Basically, he is literally shielded, again, as long as it fits the state's narrative. They basically qualify all their immunity in that. Do you think he's fearful of testifying for other reasons like personal safety? Bumpus said right. Love said that is what Mr. Melnick said to me in an email. I can pull it up. You're going to get him killed. Again, we already talked about that one. But again, there are other things going on and other reasons he might not want to testify. Then Glanville exits at 9:33. Love says, we just like to go into another courtroom and talk, give you a chance to talk to him, meaning Bumpus to talk to Copeland. Glanville comes back 1 minute later. Miss Hilton has been communicating with him. I'd like to grab her as well. So Miss Hilton's going to join the party. Then they come back basically at 10:03. So they're in recess from 9:34 to 10:03. Again, while all the defense lawyers are just waiting out there. And who is now in the meeting? Glanville, 2 district attorneys, court reporter, 2 investigators, Deputy Houston, Deputy McPherson, Sergeant Brown, Sergeant Hall with the Fulton County Sheriff's Department. So 4 more officers. So now we have 6 officers, 2 district attorneys, and a judge in there with Mr. Copeland, as they're about to explain to him how bad this could get for him. Let me see something here. All right, so page 24 is when I want us to start reading a couple pages here. We'd like to hear your testimony. That's kind of where we are at this point. So is there anything you want to ask? So now Copeland's in the room. I want to speak to you personally that I have never been truthful a day in my life until I just made this statement right now. I don't comprehend none of this stuff that's going on. So just that statement right there. If the defense counsel was in the room and he said this on the record, and now they have it, and I guarantee they're going to use it, is this not impeachment material for this witness that the defense is absolutely have a right to?
No, absolutely. The fact that he is that he doesn't want to testify. How many times does he say that? The fact that they have to keep threatening him. All that stuff is useful for cross-examination.
But specifically, if this is the state star witness and he said he's never been truthful a day in his life.
Oh, yeah.
That's pretty important for the jury to hear.
But apparently nobody else in that room thought so.
Right. There's no tactical advantage. There's nothing the defense could have learned or used in this hearing at all. Totally fair game.
Can you imagine a prosecutor not using, if a defendant ever said, I've never been truthful a day in my life? Can you imagine the prosecutor saying, oh, that's not important. I'm not going to ask you that.
No, I don't need that to prepare for trial.
Right.
Okay. Well, the only thing you can give is truthful testimony. I mean, whatever you know is whatever you know. I mean, that's it. Hilton says, and what we'll say, and Mr. Copeland and we have talked about this. I'm not sure what your concerns are, what concerns you expressed to Mr. Melnick last week. But if any of your concerns deal with being locked up, you can't. Like, there's nothing that can happen. The feds, and Bumpus said, well, that's not, and Hilton said, it is true. Bumpus says, no. I said, that's not his concern. If his concern is safety, we need to know that. Like, that's not expressed. So we don't know what the concern is, so we can try to resolve the concern. This is what I'm saying. Mr. Copeland and I have had conversations before. I understand some of his concern is potential criminal liability, hence why we gave you immunity. The federal statute of limitations is done. The state statute of limitations, done. So there is nothing, like I researched it this weekend, but those statute of limitations for what you and I talked about, which is 2015 or before, done. You cannot be prosecuted for anything you testify federally or statewide, immune, period. So if that is a concern, there is none, because you cannot be prosecuted. The federal statute of limitations is 5 years. So anything in 2015, 5 years would have been in 2020. Anything statewide, 4 years would have been 2019, finished. Next concern, what may happen in the street. You know what we have talked about, what we can do as far as living and all of that. We have had those conversations. So I'm trying to express to you, we do not want you locked up. I don't know how many times I have to tell you that. What I've got to say to you, we do not want you sitting in DeKalb or whatever they got you because of this. I know you wanted to talk to me on Friday before you walked into court. We weren't able to talk. If you still want to talk with or without Ms. Bumpus, I'm here. This is a prosecutor saying, if you want to talk with or without your lawyer, I'm here. But we do not want you in custody. Go ahead.
Let me go back.
Okay.
The federal statute of limitations is 5 years. That's a lie. There are crimes that are 10 years. There are crimes that are 20 years.
What she's talking about, do you?
No, and in fact is she's giving him legal advice.
Correct.
She's becoming his lawyer, and she's lying to him, totally misleading him about the statute of limitations on federal cases. I mean, you know, she's a lawyer. She can go look it up. Where did she get the 5 years for all federal crimes? I mean, it's absurd.
Are you saying there's not a single federal crime that's got a 5-year statute of limitations?
Sure there are, but that's not all of them.
But she doesn't say all of them.
Yes, she does. She said he cannot be prosecuted. Said, don't worry, because there's no federal prosecution because the statute of limitations is 5 years. That's what she's telling him.
She said those statute of limitations for what you and I talked about. So I think she's saying she looked up the specific crimes that he told her he committed, and she's saying those are 5 years. She could still be wrong, but I don't think she's saying all federal crimes.
She is wrong. I'm just telling you, she is wrong.
Okay. Well, here's what I'm saying. You're 100% right in the fact that she shouldn't be giving him legal advice. And if she turns out to be wrong, like you're saying, and he does admit to something in the feds prosecute him, guess what? Too bad, so sad. You're going to prison because this doesn't hold. If she's wrong, he's the one that gets screwed at the end of the day, not her.
Right. And it's not his lawyer telling him that. It's the state becoming his lawyer.
Yeah, it's horrible. It's horrible. So again, I don't know what was communicated to you on Friday. I have no idea. But what the state has assured you, which I have assured you in our private conversations with Mr. Long, as I'm saying in front of Ms. Bumpus, as I told you, that's what the order says. And that is direct or cross, the judge pipes in, and that's direct or cross. So if you are worried about the defendants, they may ask you because they may know your business. But if they ask you about things that you might think you have some liability with, you can't be prosecuted for any of those. So that's even more wrong, like you're saying, because now they're saying crimes we don't even know about. And they're still saying those statute of limitations. So you're right. Mr. Copeland, I got family members watching this trial. I don't want my nephews to hear the things that I may be involved with and think it's okay. Ms. Hilton says, but I think that's a separate conversation you have with them as an honest individual. Like, look, nephew, I've lived through this life. I don't want you to live. Don't go through what I've been through. Again, pure legal advice, pure coercion, pure just telling him exactly what he needs to do and should do, forgetting about what's best for him.
Can I interrupt for a second? Maybe I missed where you read close your ears. Did you read that part?
Have we gotten there yet?
Yes, the page before, page 26. And that you will not. Yeah, there you go. That paragraph.
You will not. This order, I don't know if you kept your copy of the order, but this order says you are immune from prosecution, any of it, literally. Judge, you might want to close your ears. If you confess to a murder on the stand, if we don't have any other independent evidence outside of what you say on the stand, you are immune from prosecution from what you say in court. So the facetious close your ears, which again, these prosecutors have no fear that the judge is going to do anything that encumbers what they want to do and what their end goal is. They know this judge is not going to reprimand them. They know this judge is not going to tell them they're doing anything wrong. They know this judge is not going to shut down this, interrogation and threaten fest that they're having with the witness, this is just proof of that. And again, we all know there ain't no statute of limitations on murder. So the advice she just gave him prior is obviously wrong when she's giving this as an example. I mean, that's crazy. Could you imagine a defense attorney being like, Judge, close your ears?
Well, a defense lawyer would be arrested if he did this stuff. Defense lawyer would be in jail if he did this stuff.
Copeland said, y'all did this intentionally. She said, no, we did not. You and I had this conversation this morning. Again, all the conversations they had. But what did I tell you when we met with each other? I said to you, you asked me, what is the one thing that's going to get me in jail? Didn't you ask me that? And I said, if you plead the fifth, and that's exactly what you did on the stand. So again, this also reminds us, and we think back to the defense saying they knew he was going to plead the fifth. And Copeland says multiple times, I told you I was going to plead the fifth. But then it seems like Hilton thinks she talked him into testifying by threatening to throw him in jail if he pleads the fifth. Then he still did it. So they knew it was an option, but they didn't think he was going to plead the fifth. I told you every day I was pleading the fifth. No, you didn't. I told you my concern.
Let me stop for a second. These things now, credibility now comes into play. Who do you believe? Do you believe the prosecutor who said he didn't, or do you believe him where he said he did? And if you remember, the defense during the hearing said they put him on the stand knowing he was going to claim the fifth, and they say, no, we didn't know he was going to claim the fifth. And he's saying, I told you every day I was taking the fifth. So this is totally inconsistent with what happened in the courtroom when the prosecutors were making their allegations about whether they knew or didn't know he was going to take the fifth.
I think it's pretty clear that they knew at some point he was going to plead the fifth, but I do think they have an argument that after they threatened him and coerced him, he said he wasn't going to plead the fifth. He said he was going to testify, and they believed him, and then that's why they put him on the stand. So I do think there's at least an argument for them there.
But who's telling the truth?
Go ahead.
Who's telling the truth?
Right.
Copeland, who never told the truth in his life.
Exactly. Yeah. The judge is probably not going to believe him, rightfully so. This week we first met in the car on Friday. First met you in the car on Friday, which again is like, what? Is Mr. Melnick your attorney? You said he's not my attorney. I haven't even talked to him. No, I never said he's not my attorney. I said I haven't talked to him. So again, by the way, waivers of counsel and all this stuff and firing has to be unequivocal. Usually there's a colloquy with the judge so that we don't have this exact issue, because this exact issue is usually read in favor of the layperson criminal defendant who has a right to counsel. We believe that your truth is your truth. We know what you've said before. I don't know what you're going to say on the stand, but what we know is pleading the fifth is going to keep you in custody. That's what I know. Now, how you answer your questions is how you answer your questions. That's Ms. Hilton. They talk about immunity some more. The immunity came after Mr. Melnick sent us an email saying my client is pleading the fifth. So even Mr. Melnick told them officially Copeland is going to plead the fifth.
So how did they know? How did they think that Melnick? How did they think Melnick wasn't his client? If Melnick is sending him the emails, they're responding to the emails by filing an immunity claim. How can they claim Melnick is not his lawyer?
It's just basically whatever suits them, whatever's better for their case at that point. And then on Thursday, once we left, is when Mr. Melnick reached out to us and said, my client is pleading the fifth. And at that point, we gave him immunity, again, responding to that, responding to Melnick again as his lawyer. He could plead the fifth if he didn't have immunity. The immunity is what gets rid of the fifth, because you can only plead the fifth if you are doing something that could reasonably incriminate yourself. And if you have immunity, then what you're saying is not going to reasonably incriminate you. We've talked about this in other cases. If you testify, you get out of custody. You stay out of custody until you're done. And if you don't testify, you have to stay until when? And again, this is when they go over the 6 or 12 other defendants that they still have to try, so he could be in custody for a long time. And this is the judge getting involved as well, telling him exactly how long he could be sitting in jail. I do want to read this page. Ms. Bumpus, so explain the independent evidence. If he says he did something and you know he's not telling the truth, what happens? If he says he did something, he did not do that thing. If you believe he did not, so if you believe that he's lying about that, then no. If he admits to doing something on the stand, And he did not do that thing. I'm going to say, is this the first time you're saying that? And we have independent evidence to prove that it wasn't him. Then what? Then nothing. What do you mean? So then he will be fine. Yes, but. So you're okay with him if he got on the stand and said things that weren't true. So she basically said that she's okay with it. But then when it's confirmed, she says, no, I want him to tell the truth. What have I always said to you? I want you to tell the truth. So she's just speaking directly to the defendant or to the witness at this point. I don't know what's going to come out of your mouth. I expect you to tell the truth. If you say something that's inconsistent with what you said before, I'm going to ask you about the inconsistencies, but I expect you to tell the truth.
Just as a note, as a prosecutor, whenever I had a witness with immunity or anything like that, the last thing you always say is, the only thing I want you to do is tell the truth. Because during cross-examination, you know that a defense lawyer is going to say, well, what did the prosecutor promise you? What did they tell you?
Yeah.
So that you always have that statement, well, the prosecutor told me to tell the truth. So that's a statement you always make sure is in there preparing for the defense cross-examination.
All right, so then we get to Mr. Copeland. If I'm saying something different, right? So when the police question me, they done question me every time they lock me up. I don't know how many times that was. I done told them whatever different story I could think of to try to finesse my way out of the situation. I don't recall what I done told them. Okay, so you can say I don't recall. It's from the state. That is how that works. I don't recall. The state literally telling him how to testify as a witness, which is very interesting. Ms. Bumpus, and he can say that to every single question. I would hope that's not the truth, because I think there are some things you do recall and some things you don't. But the things you don't recall, you don't recall. And then I will go through my process of what I do. You can talk to him about what impeachment is. That won't get you locked up. Impeachment will not get you locked up. You can talk to him about what impeachment is if he says, I don't recall. What will get me locked up? What did I tell you? I don't know. What you did on Friday, I plead the fifth. If the court instructs you, so the only thing that gets me locked up is pleading the fifth. Yes. The court instructs you, you need to answer the question. You say, I plead the fifth. Again, that's what's going to get you locked up. But if you answer the question, that will not get you locked up. Mr. Copeland, so if you don't want me in jail, why you just don't let me go after the trial is over with? You are in jail because you are not answering the questions, because you have been given immunity. The judge piped in there. Because you've been given immunity, you're only in jail because you got up here. Well, what about this? I answer the questions, you take away immunity, I answer the questions, and I plead the fifth. He doesn't want immunity. He just wants to plead the fifth, which I think is very interesting. But one of the other issues I see here as well is she is not just giving him immunity. She is guaranteeing him immunity in every sense of the word, which she cannot do. She is telling him how to answer the questions, and she is telling him what is going to happen regardless of what his answer to the questions are, which she can't possibly do because she doesn't know what's true. She doesn't know what's false. She doesn't know what he knows. She doesn't know what he doesn't know.
Well, the point is, she's giving him immunity. And again, I think I said this in the last video we did before. Giving somebody immunity and not knowing what they're going to say is just incompetence. I mean, it really is. You should definitely know, what is this witness going to say that I'm giving immunity for? Because again, as he claims here, he flat out says, what if I say I murdered somebody? Or, he flat out says that. They said, don't worry about it. As long as it's the truth, you don't have to worry about it. That's crazy.
So then Copeland says, I won't plead the fifth to things that don't incriminate me. The court said, and here's the court jumping in, the state can still give you immunity. They can give immunity to whoever they want, okay? And they can make that choice. I don't even make that choice. So if they, like I said earlier, they want your testimony, they figure it's that the jury needs to hear what you have to say, good, bad, or indifferent, and that Miss Hilton is telling you is just the truth as you know it, and let her worry about, even though you may have said different versions of whatever, that's for impeachment. That's not going to get you in trouble. What will get you in trouble is you just invoking your Fifth Amendment privilege because you have been given immunity, or as Miss Love said this morning, remember, Miss Love said, if you overtly lie about something, like if you tell a bold-faced whopper, then they can indict you on that particular charge. That particular false statement. And Copeland says, that's what they're going to do. That is what I was saying. You will be right back here. But if you say something that you know you did not do, like you admit to something you know you did not do, like murder, don't have no statute of limitations, right? So he is correcting the prosecutor on some of the stuff she says. But if you didn't do it, I can't charge you with something that you didn't do. I don't have any other evidence but you saying it. Well, a lot of times that's enough evidence or close to enough evidence. But y'all don't you can charge him with false statements and he will be back in jail. That is what I'm trying to say, Ms. Bumpus says. But and this is back to Ms. Hilton, but if I know you're lying about that, I do not intend to do that. So she's saying if he lies and says he commits even the ultimate crime, if she thinks he's lying, she's not going to prosecute him. So it's totally up to her discretion. So she totally could prosecute him for it. So that's not an immunity agreement. That's her saying, I'm going to choose what I do and don't charge you with based on what you say, based on if I think you're lying. I'm not going to charge you because I don't know your reason for doing that. But I'm not going to charge you when I know you didn't do what you're trying to say you did now. And that can be part of this. I know you didn't do it. So this is the prosecutor now judging the credibility of a witness, basically saying when he's lying and not lying, basically entering the province of the jury, because this is what the jury is supposed to do. But it's up to the judge to do that. No, it's up to the state to bring charges. I don't have anything to do with that, the judge says. He has nothing to do with bringing charges. That's up to the state of Georgia. Then Copeland says, can I call? Can I talk to my family? I will make the decision right after I hang up the phone. He's saying he hasn't been able to speak to anybody, Bumpus said. His sister just called us, Hilton said. Copeland said, y'all done me wrong. Y'all just hold me in jail. Don't let me get no PIN number, nothing. We have no knowledge. We did not know that he hasn't been able to do anything or speak to anyone. The jail system down, but y'all still putting people in. Ms. Hilton said, that part I don't know. I know we have been in communication with your sister, and your sister actually texted Miss Lassequat, I don't know who that is, to make sure you were okay. We told her physically we had laid eyes on you.
I just want to make sure that, again, viewers know, the fact you got no PIN number, the PIN is necessary to make a phone call. It's a code that they give inmates so they can make a phone call so that it gets charged to their account and that they know who they're recording when they make that phone call. And that's why they enter a PIN number. So what he's talking about is he didn't have the ability to make a phone call because they never gave him his PIN number.
Then he says, I'm talking about locking me back up. We would have to bring charges. There would be no incentive. Y'all will. We've already had this discussion. Look what you did to me. You waited till Friday to do this. I done told you every day before Friday I was pleading the fifth. So again, he says he was pleading the fifth and they screwed him by making him stay in jail all weekend. No, you didn't. As a matter of fact, our last, Mr. Copeland, this is the court jumping in. Let's see if we can get beyond this, okay? Beyond what your concern is. So this is the judge stepping in, trying to ease the witness's concern. You could have invoked your Fifth Amendment privilege. The state could have turned around and said, stop, had me go ahead and filed the motion to give you immunity. It was going to, they make that decision. They decide on a Friday. He's saying, so that could have been procedurally how it happened, but instead they just went ahead and gave you immunity. So even if you would have been more comfortable testifying and invoking your Fifth Amendment privilege, they could decide you as a witness, they want your testimony more than they do you invoking your Fifth Amendment privilege, so they give you immunity. So they gave you immunity, so you've got to testify.
Now, right there, 44, if you go up a little bit, that's where the court steps in and starts going through the actual immunity order that he entered, giving him immunity. And he explains that order in detail to Copeland. So this is the court speaking now.
Okay, so you testify about some aggravated assault or murder. They can't prosecute you on it because that is what it says in the order. The only thing that will get you in trouble is the next little paragraph. Kenneth Copeland shall be subject to prosecution or to penalty of forfeiture for any perjury, false swearing, or contempt committed in testifying or failing to testify in accordance with this order. So that's pretty much exactly what he's worried about, because all he does is lie, which is what he said.
And by the way, there's nothing wrong with a judge reading an order to defend. That part there, that made sense that the court was actually telling him what the order said.
I think a lot of what the judge did in the hearing makes sense if the criminal defense attorney was standing right there.
Yes, absolutely.
Right? What the prosecutor did, I think the criminal defense attorney would have blown up and been just horrified. But what the judge did throughout here, and what he actually said, maybe what he didn't do would have been problematic, but what he said, I don't think he would have said any differently if there was a defense attorney in the room.
Right, and that's us trying to be fair, and balanced in how we're explaining this, and that the judge's problem was he was asleep at the wheel when this was going on. There are things he should have done and didn't. His was basically a sin of omission, of not doing what's right. The prosecutor, that's a sin of commission. They committed repeatedly ethical violations and legal violations during the course of this, and the judge should have held them accountable and didn't. And that was the judge's problem, was he sat on his hands and let the prosecutor get away with whatever they wanted to get away with.
So the prosecutor then says, but what I do expect for you to do is answer questions so we can get through this, so you can go home, be with your baby for her birthday, see the dogs deliver their babies, go talk to your nephews, and do all these other things. Does that sound like coercion to you?
Sounds like trying to influence, yes, rather than just explaining the order. That's fine.
And
going beyond that, that's a question.
And he says, how do you know about my dogs? She says, because you told me. He's like, okay. Bumpus says, what's wrong? And Copeland says, I'm stressing at another level. Like, Bumpus said, I mean, Copeland said, I'm weak, man. I'm not playing. I'm dead serious, man. Like, Hilton says, this is what our position is. We do not want him in custody. We want him to tell the truth. We want him to testify. That's what will get him out of jail. And, you have to and Bumpus says, if he decides in 2 weeks he wants to testify, then what? Hilton says, if he wants to stay in jail for 2 weeks, then I don't know why you would want to stay in jail for 2 weeks. I have no idea. Bumpus says he just feels like he's under a lot of pressure right now, this second. Even at the jail, they are just, you can't give me house arrest. Hilton said, no, you can go home by taking the stand. And the court said, and come back tomorrow. We keep on saying yet, but there's no crime. We keep on saying yet. I don't know who is telling you about a crime. There is no crime. You haven't done anything wrong so why am I in jail? Copeland says, because you aren't testifying, but that ain't nothing wrong. It's not a crime. It's not a crime, but you're in civil contempt. So now they're trying to explain to him the difference between a crime and civil contempt. Were you going to say something?
No, I'm just looking
at you. Then he explains again why he's in jail for refusing to testify. Copeland says, you can't just sentence me. And Bumpus said, there is no sentence. Court says there is no sentence. Contempt is compliance. They want your testimony. That is all they want, whatever that may be. I don't know what it is, Your Honor, Copeland says about his own testimony. Hilton says, so listen, you're in jail for failing to testify, not for anything else. There is no crime. You ain't done nothing wrong. I don't know if people are telling you what we are going to charge you with. Nothing. We are not charging you. The state charges you. There's nothing we're charging you with. You are only in custody because you've decided not to testify. That's it. And we got to remember, all this happened after he said potentially he would falsely say that he committed a crime he didn't actually commit. And there's no reassuring.
And also notice what's missing here is fear of his life or fear of some kind of retribution. That's totally missing in these arguments. They say, oh gosh, he's in fear of being killed for this. Well, if I look through this, the prosecutor doesn't give a rat's about that. They didn't mention it once when they went through here, and he doesn't mention it either.
Yeah.
And that's going to be important later, because that's going to be the defense here of the judge and the prosecutor, is that this had to be ex parte because of the fear for retribution for what was going to happen to him if he testifies, yet they really don't deal with it.
Yeah, it was really just more of testifying, giving him all the reasons why he should testify, what he can say, what he can't say, how he should answer questions, and how no matter how he answers, they're not going to prosecute him. That's really what it's about.
Yeah, and the only thing he's scared about is being prosecuted. That's it.
Right. Actually, just being thrown in jail.
No.
Then they get into how he can purge and get out of jail, and he explains how purge means you do what we want you to do and you get out of jail. And he talks about how it's different than perjury, and the judge kind of explains that to him. Bumpus says, you've got to make a decision. So if he starts testifying today, he's going home today. Hilton said he should as long as he remains. But if you get up there and be like, if you don't get to testifying, and then we get into, you start saying, I plead the fifth, we're going to be back here again. Bumpus said, but if he says he don't recall to everything, he'll be okay. Hilton said, I'm not advising that, but so long as he answers the questions, that's fine. And Copeland said, I did these crimes. I'm telling you that. So again, a statement that a witness makes that is incredibly important to the defense's case and potentially exculpatory. This is Brady information. And guess what? If he goes out and he takes the stand and he does not admit to crimes and he says, I didn't do them, this is a statement under oath the defense should be able to impeach him with. Like, this is important. And I realize this witness on the stand is a little bit, and he's got some inconsistent statements and some issues, but this is still important for the defense to have. This is like the definition of Brady material. Okay, I don't know what you're talking about, but I think, so he says that I committed these crimes. She's like, all right, I don't really know what you're talking about. And Bumpus said, I think, or what you're saying is you're going to get up on the stand and say something, and Copeland has no response. And Bumpus said, did we find out if he could talk to his family? Hilton says, I mean, if it's okay, we got his sister's number. As my attorney, you gotta let me, if y'all want to talk, let me go somewhere where I can't hear you. Oh, that'll be a change. They're not going to overhear conversation between him and his lawyer. The judge is over there, so just speak low so he doesn't hear you. Hold on. Judge Glanville handed a document to Kayla Bumpus, exited the chambers. Okay. Then the court says, okay, all right, Mr. Copeland, have you had an opportunity to speak with Ms. Bumpus, your lawyer, and Ms. Hilton, the state's counsel? Have you got any other questions? He said, no, Your Honor. Is it your desire to give testimony today? Yes, sir. So that's how it ended. And that's important as well. I wish we had a transcript of how it ended the first time before he got on the stand and pled the fifth, but we don't have that because it wasn't recorded, and we just have to take people's word for it. Copeland said he told him he was going to plead the fifth. The state attorney says he said he was going to testify. All right, and then they start to get into what size are you, and there's nothing else really that we need to get in with the transcript. But what I want to ask you is, overall, what are your thoughts now that we've heard the transcript? We've heard what the judge says, the judge's arguments. We know this hearing is coming. We'll see if another judge sees it the same way as Judge Glanville.
All right. Okay. Again, here's the balance. Glanville, he holds his hearing because the state requests it. Fine. The state can request a hearing. Then he should have asked the question, what is the emergency? Why do we have to do this ex parte? He really didn't do that. And we also know that after this hearing now, he's made a decision that it shouldn't have been ex parte. Otherwise, he wouldn't have turned over the transcripts because nobody else, no other judge is ordering him to turn the transcripts over. It's the decision he made. So he made a decision. There's nothing that happened in that hearing that the defense can't know, number one. Number two, he should have decided that during the course of the hearing when he discovered that there really wasn't an emergency. And therefore, he should have stopped the hearing and he should have allowed defense counsel to say, look, we're not going any farther until defense counsel is here at the hearing so they can be represented. He should have done that. His defense is going to be that this was a situation of retribution against the witness, so that's why it was an emergency, which there is case law that says you can't have an ex parte for that. That's his defense. But if you read the entirety of the transcript, it shows nobody was focusing on retribution. Nobody was focusing on him getting hurt because he testified. They were all trying to intimidate him into testifying and not take the fifth. It was all about that, nothing else. So the emergency nature was zero zilch, even though they're going to claim it. His sin was he did not do what a judge is supposed to do. The prosecutor was absolutely the worst. We learn all sorts of stuff about the way they conducted themselves, but it's up to the judge. He's supposed to be the neutral guy that sits there and calls balls and strikes and makes sure that the defendant gets a fair trial. He didn't do that. That's really the bottom line.
The only thing I can think of as we read this entire transcript is the defense attorney being there would have solved all the issues. There's no reason not. It's not like if anything, the state attorney accused this witness and his lawyer of conspiring with the defense attorneys and the defendants more than she accused them of potentially doing physical harm to this witness or potentially learning something that would be dangerous for this witness, which would be a reason to keep the defendant out if that was going to immediately put his life in danger. But instead, she's saying, I don't know whose interest you guys are looking out for. And he's saying, I did these crimes. All I've been doing is lying. All that stuff is good for the defense.
Plus, think how the atmosphere would have changed if when Steele got up there and said, there was this ex parte hearing, and judge goes, you know what? You're right. I acknowledge that we have the ex parte hearing, Mr. Steele. You know what, Mr. Steele? I'm turning over the transcript to you here. This is going to be all done. Then, read the transcript, and then you can come back and make whatever arguments you want. Just think how much different this would have turned out. But instead, he was, again, the cover-up was worse than the crime. Again, he tried to cover this up. I mean, he really did. And I'm really surprised because he really shouldn't have. He just should have turned the transcript over.
Yeah, and that's the annoying part and the frustrating part. But I mean, this case is like never ending. So from what you saw in the transcript, do you think that they will recuse or disqualify Glanville from continuing on this trial? Do you think anything that happened in this ex parte hearing would cause for dismissal of the trial or anything to that level of a remedy?
No, there won't be a dismissal of the trial. In the law in Georgia, interestingly enough, if another judge is appointed, he actually can take over at the spot that this happened in the trial. Now, I don't know how that can possibly happen in a trial. It's been going on since November, but that's one of the options that the courts have. I don't know if it's going to be enough. I got to be honest with you, because judges, of course, give the presumption of correctness to other judges when they're looking through these transcripts. And if you look at just the words of the court, just the words of the judge, they aren't as horrible as the prosecutor. I don't know if omission is a reason for him to be disqualified. So I got to be honest, it's not a slam dunk win for the defense that they're going to recuse him. Go ahead.
I am pretty horrified at the conversations that were happening, but I did think it was going to be worse coming from the judge than it was. So I could see this one going either way, kind of like you're saying too. If I had to bet, I would say he's not going to be recused, especially if they pick a judge from his jurisdiction. And I don't think it rises to any level to dismiss the case, but I definitely think the defense should be able to use everything that was said, including what the prosecutor said to Mr. Copeland, and the jury should get to hear that.
Oh, yeah. There should be wide latitude in cross-examination on this. The judge should let them just rip the prosecutors apart from this transcript.
They're giving you federal immunity, and they don't even have the ability to do that.
Right. And they're wrong. And they're wrong on what they advised him and did all sorts of stuff to trick him to testify. And these were tricks. He was tricked into waiving his Fifth Amendment right. But yeah, it's going to be, and I tell you another thing, and this is kind of a side note, but Ms. Bumpus gave an interview and was asked, were you the one that revealed what happened in this hearing to Mr. Steele? Were you the initial person to do that? And she said, no, she was not, that they knew about it already from another source. Then later on at a break that day, she met with 4 of the lawyers and did disclose what happened, but they already knew about it before she told them. And so I thought that was an interesting fact. So now the prime suspect, prime whistleblower, as we would call her, is not the prime whistleblower. There is somebody else out there that revealed this to the defense.
Yeah, that's interesting. I wonder if it was Copeland himself or
maybe one of the court personnel. Maybe a court personnel made a comment or said something, offhanded, innocent comment, and the defense lawyers picked up on it.
Yeah, that's really interesting. I mean, to think that this all can happen and think the defense lawyers aren't going to find out about it is pretty wild. So where we go from here is we take a break. We wait for this recusal hearing to happen. Then we come back to trial. They get to use all of this when they cross Kenneth Copeland, which is happening at some point. But this is going to take forever.
Yeah, another thing too. What about these jurors? Think about it. First of all, it's got to be it's got to be assigned to another judge to hear this hearing. Then there's going to be this big hearing.
Well, they won't know about that necessarily, but
no, they won't know about it. But it's the delay. They're going to sit at home for weeks, maybe months before this trial starts again.
That's so sad. They have to sit at home for that period of time without working, and they can't get a job because they don't know when they're going to get called to court. But they get $25 a day, and that's just horrible. That's all they get. Some people are under the assumption that they get lunch. They don't get lunch. They do get parking if you have a car. I've heard them say, now I know here we get, like if you have to ride the train or the bus, they give you passes, but I don't know about there. But I do know that they're not getting paid for their food. They're only getting $25. And then also the state's witnesses get $25 a day. So just like they're getting $25, so is Mr. Copeland. He's getting $25 a day as long as he's a witness. So we're almost at the end. It's this one. I'm not going to play the one where they read the transcript. It's about 6 minutes. I'm going to do the one. Let me see. I want to do this one where they say that he made mistakes. Let me see. It might be this one. Oh, you know, he said that he was going to redact the transcript. Then he said he wasn't going to redact the transcript. Then he said he put out the real transcript. But reading this and listening to what some of the stuff we've heard already and may have seen somewhere else, it sounds like he redacted the transcript. It doesn't make complete thoughts, and they're having conversations that you didn't hear them have in that meeting, which I believe some of that stuff took place outside of that meeting. I think it took place that Friday. And that's just based on, again, my observation. But here we go. This is like about 6 minutes, I think.
Is out and is causing waves among those observing the YSL trial. As a point of reference, Judge Glanville conducted a secret ex parte meeting on June 10, 2024, with Woody Copeland and the YSL trial prosecutors. Many people believe Woody to be the prosecution's star witness. Controversy arose when lawyers for rapper Young Thug and other YSL defendants learned about the meeting and complained that they had not been invited. This set off a chain of events which resulted in Glanville agreeing to submit himself to a recusal hearing and releasing a transcript of the ex parte meeting. Observers had expected Glanville to release a complete unredacted account of what transpired. But now, after reviewing the transcript, many are questioning whether the document had been redacted. Here are 5 top theories of potential redactions to the Glanville ex parte meeting transcript. At numerous points, the conversation jumps around, with people seemingly making reference to things they had said earlier. Only those presumed earlier parts of the conversation are not included in the transcript. This could be due to the fact that the transcript records natural human conversation, which can jump around quite a bit and where people speak over one another frequently. It could also reflect that some parts of the transcript have been redacted. Here's an example. Number 5. Bumpus mentions here a refundable ticket as if she had already told the others about it, but this is the first time she mentions it. Also, Bumpus seems to randomly say that she tried to go back and watch as much as she could, but she never says what it is that she tried to watch. Mrs. Love. See, that's not in Mr. Copeland's best interest. That's in the defendant's best interest. When you say switch in how he gets called, what does that have to do with anything? Mrs. Bumpus. I don't know. Maybe he's saying he can't do it because he can't get his refundable ticket. Mrs. Love. That is not what he said in that email to you, and that is not what he relayed to the court. And his concerns have nothing to do with the court. He was very much Mrs. Bumpus. I tried to go back and watch as much as I could. And here is another example in which Mrs. Hilton says, we keep on saying yet. But when you search the transcript, no one had said yet until Hilton mentioned it here. There's no, we keep on saying yet, but there is no crime. We keep on saying yet. I don't know who is telling you about a crime. There is no crime. You have done nothing wrong except for not. Number 4. One of numerous examples of where Mrs. Hilton seems to be suggesting to Woody that he should say something untrue, or at least that she will allow it. Was there more to this part of the conversation that the transcript left out? Mrs. Hilton, what you are saying is not perjury. What you are saying is what we call a prior inconsistent statement. Your example that you gave me, what if I said I did something and I know you didn't do it, and you said before you didn't do it? That's not perjury. That is a prior inconsistent statement. Number 3, Lieutenant Dean entered the chambers and said there was a security issue. Judge Glanville and Lieutenant Dean exited chambers at 10:45 a.m. Judge Glanville returned to chambers at 10:47 a.m. The very next line is Mrs. Hilton continuing to talk to Woody. But when Glanville returns, he makes no mention of the nature of the security issue or why he had to step away. What is the chance that Judge Glanville will be called out of his chambers, especially for a security issue? And when he returns, he does not make any kind of statement to those present as to what happened, not even asking them to excuse his absence. Something seems to be missing here. Number 2, this back and forth at a minimum seems to be Mrs. Hilton allowing Woody to lie about certain crimes, which is very troubling. At worst, an even more damaging part of the conversation may have been omitted. Mrs. Hilton, but if you say something that you know you did not do, like you admit to something you know you did not do, whether you, Mr. Copeland, like murder don't have no statute of limitations, right? Mrs. Hilton, but if you didn't do it, I can't charge you with something you didn't do because I don't have any other evidence but you saying it. Mr. Copeland, but y'all don't, like Mrs. Bumpus. You can charge him with false statements and he will be back in jail. That is what I'm trying to say, Mrs. Hilton. But if I know that you are lying about that, I do not intend to do that. If I know right now he's lying, I know he's lying. I'm not going to charge you because I don't know your reason for doing that. But I'm not going to charge you when I know you didn't do what you are trying to say you did now. And that can be a part of this. I know you didn't do it. Number 1, at one point Woody Copeland blurts out, I did these crimes, seemingly without having first discussed to which crimes he was referring. It seems like some part of the conversation was left out. To what crimes is Woody referring? For context, here is that part of the conversation. Mrs. Hilton, he should, so long as he remains. But if you get up there and be like, if you get to testifying and then we get into it and you start saying, I plead the 5th, we're going to be back here again. Mrs. Bumpus. But if he says he don't recall to everything, he'll be okay? Mrs. Hilton. I'm not advising that, but so long as he answers the questions, that's fine. So long as he... Mr. Copeland. I did these crimes, I'm telling you that. Mrs. Hilton. Okay. I don't know what you are talking about, but those are 5 places where we found that the transcript may have been redacted. Do you agree with us? Did you find other locations that seem to be redacted? Tell us in the comments.
Okay. What did y'all think? I know y'all probably aren't going to say anything, but if you decide to leave a little message, you can say something in the comment section. But that was about it. And I hope y'all got a bigger picture and a better understanding of the use immunity, the derivative immunity, and the transactional immunity, which of course I've started the video off with that definition. And it'll really help you understand that they really mean him no earthly good. None whatsoever. So I put, just in case anybody decide that they want to file a complaint, if you know anybody that live in Georgia that may want to file a complaint and don't know what to do or how to find it, all they have to do is hit this link and it'll take them to that page, and you just pick who you want to file the complaint on and fill out the application. Nothing is going to change for us if we don't change it. Nobody's going to come and save us, not in this life. And we don't have to keep living like this, especially because we vote. We spend money. We have our being here. We rear our children, and actually it's not safe for nobody. And it's because of the conditions of the 1% over the 99. So we got to start thinking as if we're 1% and start looking out for our babies. That's what we have to do, because we're not going to be here always. And the way things are going, again, what's happening to these young men can happen to any of us. It can even happen to us women. So we have to really, get serious. I know that a lot of people say that this stuff is entertaining. It's disheartening to me. And I just do my little part. And I really hate that you guys can enjoy just watching the video with all of the spinning and stuff. I got the little Ethernet thing, so I'll try to find out what's going on so it could be better, because trust me, I really appreciate each one of you that shows up every Wednesday and every Sunday. No matter who you are, I thank you. And on that note, y'all know the children are my future. So we're going to teach them well, and we're going to get out of here. I thank y'all for staying almost 5 hours with me, going through the painstaking cutting off. That is so nerve-wracking, but I'm just not that great with the computer, and I'm trying to get this stuff where it can at least show. I want everybody to have a beautiful night, a safe 4th of July. Hope y'all get some barbecue. I don't think we're going to have any, but I hope y'all enjoy yourself. I'm going to have a lazy day. And on that note, I'm leaving the Tiger's Den. Goodbye. I believe the children are our future. Teach them well and let them lead the way. Show them all the beauty they possess inside. Give them a sense of pride to make it easier. Let the children's laughter remind us who we used to be. Everybody's searching for a hero. People need someone to look up to. I never found anyone to fulfill my needs. A lonely place to be. So I learned to depend on me. I decided long ago never to walk in anyone's shadow. If I failed, if I succeed, at least I'll live as I believe. No matter what they take from me, they can't take away my dignity, because the greatest love of all is happening to me. I found the greatest love of all inside of me. The greatest love of all is easy to achieve. Learning to love yourself is the greatest love of all. And if by chance that special place that you've been dreaming of takes you to a lonely place, find yourself in love.